Senator Carson, would you please lead us in the Pledge of Allegiance?
Thank you, Mr. President. Please rise in the chamber and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Approval of the Journal, Senator Mullica. My man.
Thank you, Mr. President. I move that the Senate Journal of January 30th, 2026 be approved as corrected by the Secretary.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes still have it. The motion is adopted. Senate Services.
Correctly printed, Senate Joint Resolution 7. Correctly engrossed, Senate Joint Resolution 4.
Mr. Majority Leader.
Thank you, Mr. President. I move that the Senate proceed out of order for a moment of personal privilege.
The motion is that the Senate proceed out of order for moments of personal privilege. All those in favor say aye. Opposed, no. The ayes have it. We proceed out of order for moments of personal privilege. Mr. Schaffler, please add Senator Danielson to the roll. Madam President Pro Tem.
Thank you, Mr. President. We have some guests in the chamber, and I'll ask them to stand. They are from the, may I ask for a moment of personal privilege?
Granted.
Thank you. Our guests in the chamber are from the Congressional Office of International Leadership Open World Program, and they are delegates who represent both chambers of the Polish Parliament. So if you've got any Polish heritage, make sure to come over and say hello. And if you don't, please come and say hello to our delegates from Poland, and let's give them a warm welcome.
Welcome to the Senate. Madam President Pro Tem.
A quick moment of personal privilege.
Granted.
Today is the Jewish holiday of Tu B'Shvat. And on Tu B'Shvat, you eat dried fruit because it is the celebration of when the trees begin to fruit. So if you'd like any dates, come visit my desk and I have some and we can celebrate Tu B'Shvat together. Thank you.
Thank you very much. Mr. Schaffler, please add Senator Snyder to the roll. Majority Leader Rodriguez.
Thank you, Mr. President. I move that the Senate proceed out of order for the consideration of resolutions.
The motion is to proceed out of order for consideration of resolutions. All those in favor say aye. Opposed, no. The ayes have it. The motion is adopted. We'll proceed out of order. Consideration of resolutions. Mr. Schaffler, will you please read the title of SJR 26001?
Senate Joint Resolution 001 by Senators Robertson, Catlin, Representatives McCormick and Winter T concerning approval of water project revolving fund eligibility list administered by the Colorado Water Resources and Power Development Authority.
Senator Roberts.
Thank you, Mr. President. I move Senate Joint Resolution 001.
Any discussion? Senator Catlin.
Thank you, Mr. President. Members, I wanted to just reaffirm the fact that these are the kind of things I think state government should be doing. Colorado has been a leader in helping with our clean water and our tailwater, our wastewaters that go back into the state's waters. These are the kind of projects, and if you take a look at the list, you'll probably find somebody in your district is a recipient of grants and loans from this program. This is a strong program. We need to keep it strong, so I'd ask for a yes vote.
Further discussion? Seeing none, the motion is the adoption of Senator Kirkmeyer. Come on down.
Thank you, Mr. President. Could you give us the dollar amount with regard to the projects? Was that in the resolution? Just approves them for eligibility? Okay. But could you, either one of you, give us an idea of the dollar amount that we're trying to fund this year out of the revolving fund, please? Anybody know? Thanks.
Senator Roberts.
Thank you, Madam President. Thank you for the question to the good senator from Weld County. So this is the resolution that we're required to in order to make these projects eligible for funding. This is not the water projects bill. That will be a different bill later in the session. This is for funding from the Colorado Water and Power Development Authority for wastewater and clean drinking water projects. So it's a combination of federal funds and other funds. There's no dollar amount attached to this resolution. This is the way the legislature set it up many decades ago, that we had to run a resolution first and then they get funding later. Yep.
Senator Catlin.
Thank you, Mr. President. To address some of your questions, this is the one that's a revolving loan fund. As our communities pay back, we reloan those dollars out. So I will get with you later. Thank you.
Seeing no further discussion, the motion is the adoption of SJR 26001. Are there any no votes? With a vote of 32 ayes, 0 no, 0 absent, and 3 excused, SJR 26001 is adopted. Co-sponsors. Nobody wants to make a unanimous. Mr. Senator Roberts.
Thank you, Mr. President. If there's no objection, I'd ask that the current roll call be added as co-sponsors.
Seeing no objection, the current roll call will be added as co-sponsors. Mr. Schaffler, please read the title of SJR 26006.
Senate Joint Resolution 006 by Senators Judah and Weissman and Representatives Joseph and Ricks concerning the commitment to Coloradans navigating the complex United States immigration system and ensuring transparency and federal enforcement in our state.
Senator Weissman.
Thanks, Mr. President. We move SJR 006. We do ask that it be read at length.
Mr. Schaffler, please read SJR 26006 at length.
Whereas immigrant Coloradans are students, workers, business owners, caregivers, parents, faith leaders, longtime residents, and new arrivals who together shape the civic, economic, and cultural life of our state. And whereas in 2025, the Colorado Fiscal Institute reported that immigrants in the state of Colorado contribute $2 billion in state and local tax revenue annually, a significant contribution to our economy. And whereas immigration in Colorado reflects a broad and complex spectrum beyond the binary of documented and undocumented, including deferred action for childhood arrival recipients, asylum seekers, temporary protected status holders, international students, refugees, survivors of trafficking and domestic violence, seasonal workers, and mixed status families. And whereas when immigrant community members are unjustly targeted or subjected to opaque enforcement practices, it undermines not only individual rights, but the health, safety, and well-being of all Coloradans, disrupting schools, healthcare systems, workplaces, and families. And whereas a 2021 report by the American Immigration Council shows 17.8 million children in the United States have at least one foreign-born parent, and as many as 500,000 United States citizen children experienced the deportation of at least one parent between 2011 and 2013. And whereas additionally, a 2020 study by the American Immigration Council reported that detention or deportation of a family member resulted in significantly higher rates of suicidal thoughts, alcohol abuse, and aggression. And whereas Colorado is taking meaningful steps to recognize and protect the civil rights of immigrant community members, including the passage of House Bill 19-1124, Senate Bill 21-131, Senate Bill 25-276, and other measures that promote transparency, limit discriminatory practices, and reinforce the dignity and equality of residents regardless of immigration status. And whereas heightened federal enforcement rhetoric coupled with immigration enforcement actions carried out without clear identification or accountability has contributed to increased fear, confusion, and racial profiling of Black and brown Coloradans, disproportionately impacting immigrants in African, Caribbean, Latin American, Middle Eastern, and Asian communities in Colorado. And whereas the Colorado Polling Institute found in November 2025 that a majority of Hispanic voters feared unlawful detention of their community members, and that 64% of Coloradans are concerned that Immigration and Customs Enforcement, ICE, is detaining people who should not be detained, and whereas the use of masked or unidentified personnel and unmarked vehicles in civil immigration enforcement, which represents a form of de-individuation, increasing the likelihood of aggressive antisocial behavior, has led Colorado community members to reasonably fear arbitrary detention, impersonation, or abuse of authority resulting in avoidance of schools, public transit, healthcare facilities, faith spaces, shelters, civic centers, and other essential services. And whereas such fear erodes public trust, impedes community cooperation, and compromises public safety by driving people away from institutions intended to protect health, education, and well-being. And whereas when schools are disrupted or parents are forced to live in fear, children experience psychological trauma that can impair learning, health, and long-term well-being, with consequences that reverberate across families, communities, and generations. And whereas in Minnesota, a state that has experienced heavy ICE presence, the total number of school absences increased 13% among Spanish speakers, 8% among Karen speakers, and 6% among Hmong speakers between December 1st, 2025 and January 6, 2026. And whereas allowing ICE presence to affect our students in Colorado schools could have dire consequences for the state, as chronic absenteeism is linked to lower high school graduation rates. And whereas Renee Good was killed by an ICE agent on January 7, 2026, while trying to follow direction to leave. And whereas Alex Preddy was killed by an ICE agent on January 24, 2026, while protecting a woman being beaten by ICE agents. And whereas the lives of 32 immigrants were lost while held in detention centers in 2025 due to inhumane conditions and lack of access to health care, while survivors have an increased likelihood of mental illness and PTSD, especially if their detentions surpass 6 months. And whereas according to a 2025 report by Physicians for Human Rights, ICE facilities subjected over 10,500 individuals to solitary confinement for on average 38 consecutive days, more than double the 15-day threshold for torture as defined by United Nations human rights experts, as well as isolating individuals with vulnerabilities such as mental health issues nearly twice as long as compared to 2022. And whereas so far under this presidential administration, there have been a reported 20 cases of civilians posing as ICE agents for nefarious reasons, demonstrating that face coverings and agents' failure to identify themselves pose a threat to all Coloradans and erode public trust in law enforcement. And whereas state, local, and federal governments share responsibility for ensuring that enforcement practices are carried out in a manner consistent with constitutional protections, civil rights laws, and fundamental norms of transparency and accountability, preventing discrimination, trauma, and unjust detainment. And whereas the General Assembly affirms that true community safety requires transparency, legal clarity, and the ability for all residents to move, work, learn, worship, seek care, and live without fear of coercive interaction or identity-based targeting. Now, therefore, be it resolved by the Senate of the 75th General Assembly of the State of Colorado, the House of Representatives concurring herein, 1, that we, the members of the Colorado General Assembly, A, reaffirm the civil rights of immigrant Coloradans and affirm that dignity, belonging, family unity, and freedom from intimidation are fundamental rights of all who call Colorado home. B, support the right of members of the public to robustly exercise their First Amendment rights to free speech and to petition their government for redress and urge that all protests be peaceful in nature. C, call on federal agencies to end anonymous enforcement tactics and urge immigration authorities, when operating within Colorado, to adopt enforcement practices that are transparent and accountable, including by immediately ending the routine use of masked or unidentifiable personnel, unmarked vehicles, and plainclothes detainment without prior identification, requiring visible agency identification and prompt disclosure of name, agency, and badge or credentials upon engagement with the public, and ensuring that residents can readily distinguish lawful officers from private actors, vigilantes, or impersonators. D, call upon federal agencies to protect community access to education, healthcare, and civic participation, and aid and refrain from civil immigration enforcement actions in or near courthouses, schools, health clinics, faith spaces, food distribution sites, and civic gatherings, except in narrowly defined circumstances involving a verified and imminent public safety threat. E, advocate for modernized, humane federal immigration reform. F, call on Congress and federal leadership to pursue for reforms that reflect lived realities and economic needs, including creating functioning, timely pathways to citizenship for long-term residents, dreamers, and mixed-status families, expanding worker protections and lawful labor pathways that reflect Colorado's economic reality, strengthening protections for survivors, refugees, and asylum seekers, and modernizing processing systems that currently leave families in indefinite limbo. G, support state-level transparency measures and urge continued investment in state-level oversight, community reporting mechanisms, and public transparency tools to ensure compliance with civil rights standards and to prevent discriminatory or covert enforcement practices within Colorado. H, declare that Colorado is home to one of the most diverse immigrant populations in the country and that immigrant Coloradans contribute to every sector, from education to healthcare to construction, entrepreneurship, public service, and culture. I, reaffirm that ensuring immigrant Coloradans' ability to live safely and move without fear is not a partisan preference, but a matter of constitutional dignity and collective well-being. And J, call on federal partners to uphold transparency, accountability, and humane enforcement practices so that every family, regardless of immigration status, may participate fully in the communities they have built and sustained.
Senator Weissman.
Thank you, Mr. President. Mr. Schaffler, thank you for reading that. Members, thanks for listening. We know that there are folks here who want to engage in the subject today and also listening online, and we thought that the record should incorporate in fullness what we're about to talk about. I'm not going to say a lot about the resolution itself. You just heard it. You've had a chance to read it. We hope it speaks for itself. More importantly, we hope that what it speaks of in terms of what's been going on in cities and towns all over our country speaks for itself. So I was instead going to share a story, but before getting into that, we did just want to clean up one minor detail in the amendment itself.
There is an amendment at the desk. Mr. Schaffler, please. Oh, hold on first. Senator Weissman. Did you move it? Did you move it? Mr. Schaffler, please read L001.
Amendment
Senator
L001.
Weissman.
Thank you, Mr. President, and I misspoke. We need to fix the detail in the resolution, therefore I move L1 to SGR 6.
To the amendment.
All right, members, this reflects language on page 3. As I think we know, there are different units of the federal department, DHS. ICE is one unit or agency, CBP is another. Mr. Preddy in Minnesota was killed by CBP. That was incorrectly stated in the introduced version. I apologize for that. This is to state what's happened correctly. Putting aside your ultimate views and intentions on voting on the resolution, we need to get the details right, so we ask for your support for L1.
Further discussion. Seeing none, the motion is the adoption of L001. Are there any no votes? With a vote of 32 ayes, 0 noes, 0 absent, 3 excused, L001 is adopted. Senator Weissman.
Thank you, Mr. President, members. Thank you for that. Now on with the story that I wanted to share this morning. In 1911, a boy from a patch of earth in Eastern Europe, now called Ukraine, got off a boat in New York, having come by way of Antwerp to start a new life. This was in the time of the pogroms, when people like him could be persecuted and killed because of their religion. He didn't speak any English. His whole family spoke Yiddish. But he learned the language and hustled his way through high school and college, becoming the only one of his 6 siblings to do so. In 1931, he graduated from medical school, and in 1932, he submitted his petition for U.S. citizenship at the age of about 27. In the 40s, he served his country for a time as a captain in the Army Medical Corps. In 1985, he retired, having practiced medicine for more than 50 years, sometimes seeing low-income immigrant patients, like he himself had been, and taking payment in kind when patients didn't have money to pay for his services. In the mid-1990s, in the last years of his life, he urged his grandsons to go into medicine to be able to help people as he had in his career. Maybe you've guessed by now that I'm talking about my grandfather. He was born Meyer T. Weissman, but went through life in this country as Michael T. Weissman, because then, as now and as ever, immigrants have always struggled both to maintain their own culture and history and to assimilate to new traditions. As the first grandchild to any of my grandparents, I was named after him. Obviously, my path was not medicine. My path, a long and winding one, led me here. As a member of the Senate Health Committee, I often think of his late-in-life exhortation and how I get a chance to participate in what he cared about, just in a bit of a different way. And also because my path led me here, I get to stand in this spot of privilege, debating subjects like we're debating today. And I get to beg all of us in this chamber to remember that somewhere in our family histories, probably in multiple places, we all have stories like the story of Meyer T. Weissman. Because the story of the East United States is the story of people coming here from somewhere else over centuries for all manner of reasons, most of those reasons pretty desperate, to seek a new beginning, to seek, to borrow the words of another document, a new birth of freedom, and to seek equal treatment under our laws. Because throughout history and today around the world, it is still way too hard to find that. So I hope as we consider this measure before us today, we resolve to not forget our personal histories. We resolve to not forget our national history. We resolve to not lose sight of the constitutional protections that more than race or ethnicity or language or religion make this country what it is and who we are. I hope we don't think that the path to national prosperity and security runs through pulling shut the golden door or snuffing out the lamp beside it. As Langston Hughes said, we the people must redeem the land, the mines, the plants, the rivers, the mountains, and the endless plain, all the stretch of these great green states, and make America again. In that spirit, I ask for your support of SJR 006.
Mr. Minority Leader.
Thank you, Mr. President. Good morning, colleagues. A few thoughts about the resolution. First, extend a heartfelt thank you to the sponsors for their willingness to engage with me last week before the before the resolution was introduced. Really appreciate the level of professionalism and dignified conversation we had. The resolution as drafted, I can't support, but I can't help but think about there was an opportunity. There's much of the resolution that I'm in agreement with. There are certain parts of it that I just can't support, and I think we missed an amazing opportunity to, given more time, and I appreciate there are lots of things happening in this space, but more time, maybe it's really kind of maybe wishful and hopeful thinking that we could come to a spot where I could actually come up and be supportive, because ultimately, I think what we all aspire to is in this conversation, particularly about immigration, is that people feel respected and that we treat people with an abundance of dignity and respect. That's the outcome that should come out of this, whether you're part of the immigration community, whether you're part of law enforcement, whether you're part of the folks that are subject to some of these enforcement actions. And certainly been demonstration more recently where that is not the case. And I can speak of some very specific instances, even within my district, where I thought there could have been and should have been a different approach to enforcement actions that just troubled me to watch unfold. So I think there are opportunities for us to be much better in this space. When I go through all of the whereases in the resolution, again, there are a number of them that, like, yeah, this makes sense, again, in that space of treating people with dignity and respect. I thought we were missing something there, though, about thinking about, you know, the failed, there's actually a part of in the therefore place where we've just had really a long history of really poor federal immigration policy that has not helped us get to a much better spot. I think of even under Democratic leadership, the deportation of more than 2 million immigrants here, and go, we've failed, our system is failing if we reach that point where there are 2 million people here that are subject to enforcement actions and deportation. I think again about more recently about watching caravan after caravan after caravan of folks, largely made up of folks trying to make their lives better. But I don't think you can just ignore the fact that embedded in those immigrant populations are folks that don't have our community's best interest at mind. And I mean, that exists in the immigration community, and it exists outside the immigration community as well. I think about, again, some of the rhetoric and implications, bounties on law enforcement officers. We just have to be much better in this space. I do absolutely believe in the therefore part of the resolution, striving for better outcomes, and a couple of those are spot on. Absolutely, there's a reference there that again we can be better in this space. I struggle a little bit, and I hearken back to Governor Cox from Utah last year after the killing of Charlie Kirk, and his speech about really trying to find an off-ramp out of this space. Like, I'm dedicated to working in this area to find an off-ramp so that we can be constructive in our conversations And look, the resolution isn't terribly offensive to me. There are some pieces of it I think I would have suggested different language. And the sponsors did agree and made some minor changes to help bring my comfort level up somewhat. So I just committed to this session in particular, and really my life, finding those, help building and construct those off-ramps to get us to a much better space where we can have constructive, engaged dialogue, all in an attempt to make life better for Coloradans. And I appreciate the opportunity. Thank you again, sponsors, and thank you, Mr. President.
Thank you. Senator Judah.
Thank you, Mr. President. I too want to follow in the footsteps of my co-prime, and rather than speak to the amazing words of the resolution, tell a story. Nearly 60 years ago, my father, Muhammad, carried with him a degree and some experience as an accountant from around the Middle East, and a simple dream: to return home to Palestine, to build a family on the land that shaped him. But when that right was taken from him, that dream closed, suddenly and painfully. So with humility and resolve, he turned towards another promise, the promise of the American dream. My father did eventually make it back to visit Palestine, briefly. And in that visit, he met and married my mom in 2 weeks. When you know, you know. But they also did not have the luxury of staying in their homeland. Instead, they settled here in Colorado, where my father built a life rooted in service and in faith. He became a successful businessman, a community advocate, a faith leader, and for years he stood where our president stands, offering the opening prayer in this very chamber. 50 years after my father began his American journey, another young man found himself facing a similar crossroads. Unable to remain safely in his native Iraq, he too turned to the United States to imagine a future. My husband served as a combat interpreter for our U.S. troops in Iraq, risking his life, the life of his family members, because he truly believed in rebuilding Iraq in the image of his own people. And like my father before him, he would go on to serve his community, become a nurse, an advocate, and even the district director for a U.S. congressional office. My husband was once told that he was, quote, one of the good ones, because his version of the American dream dictated his worth, and that it neatly fit in someone else's idea of who deserves belonging. Much has changed in the past 60 years. Our world has changed, our nation has changed, but one thing remains constant: the essence of what the American dream is. Whether it was my father decades ago or my husband generations later, the story is strikingly familiar for so many who come to this country in search of safety, dignity, and opportunity, also known as life, liberty, and the pursuit of happiness. Friends, immigrants are not a concept. They are human beings. They are my parents, my husband. They are our farm workers, our faith leaders, business owners, elected officials, service members, doctors, and most of all, our neighbors. I heard a quote recently: "There is no becoming without healing, and without radical acceptance of one's truth." We are a nation in need of healing, and we are a people in need of one another's humanity. but healing requires honesty. It requires us to confront the reality of who we are as Americans and who we claim to be as Americans, to what we committed to be on paper. That we as a nation have etched literally in the beacon of freedom at our country's gates. Give me your tired, your poor, your huddled masses yearning to breathe free. And there is no becoming, no true fulfillment of our democracy without recommitting to its most fundamental promise. We hold these truths to be self-evident, that all men are created equal, that they are endowed by the Creator with certain unalienable rights, that among these rights are life, liberty, and the pursuit of happiness. And to me, that truly sounds like the American dream for all. Thank you.
Further discussion? Seeing none, the motion is the adoption of SJR 26006. Are there any no votes? Senators, Mr. Minority Leader Frizzell, Kirkmeyer, Rich, Samora Wilson, Pelton B., Bright, Carson, Catlin, Pelton R., Liston, Baisley. With a vote of 20 ayes, 12 noes, 0 absent, and 3 excused, SJR 26006 is adopted. Co-sponsors, Senators, Mr. Majority Leader Amabile, Cutter, Danielson, Marchman, Wallace, Gonzalez, Kipp, Michelson Janae, Roberts, Mullica, Exum, Colker, Lindstedt, Sullivan, Ball, Snyder. Please add the president. Second reading of bills. Consent calendar. Senator Roberts.
Thank you, Mr. President. I move that the Senate resolve itself into the Committee of the Whole for the consideration of second reading of bills, consent calendar.
For the motion, all those in favor say aye. Opposed, no. That motion is adopted, and the Senate will resolve itself into the Committee of the Whole for consideration of General Order Second Reading of Bills Consent Calendar. Senator Roberts will take the chair. Get your son back.
The committee will come to order. Will the clerk please read the title of the bill on the general order, second reading of bills, consent calendar?
Senate Bill 10 by Senators Roberts and Pelton B. and Representatives McCluskey and McCormick concerning clarification of definitions used in connection with the taxation of agricultural property.
Mr. Majority Leader.
Thank you, Mr. Chair. I move for the adoption of the bill on the consent calendar, which includes Senate Bill 10. There are no committee reports.
You have heard the motion. Is there any discussion on on the bill on the consent calendar? Seeing none, the motion before us is the adoption of the bill on the general order, second reading of bills, consent calendar. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that bill is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
You have heard the motion is for the committee to rise and report. All those in favor say aye. Those opposed, no. The ayes have it, and the committee will rise and report.
Senate will come to order. Senator Roberts.
Thank you, Mr. President. The committee has had one bill under consideration. Will the clerk please read the report?
February 2nd, 2026. Mr. President, your committee of the whole begs leave to report it has had in consideration the following attached bills being the second reading thereof and makes the following recommendations thereon. Senate Bill 10 passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage.
Senator Roberts.
Thank you, Mr. President. I move the adoption of the report.
The motion is the adoption of the committee of the whole report. Are there any no votes? With a vote of 32 ayes, 0 no, 0 absent, 3 excused, the committee of the whole report is adopted. Senate Bill 2610 passed the second reading, order engrossed, placed on the calendar for third reading and final passage. General orders. Second reading of the bill, Senator Roberts.
Thank you, Mr. President. I move that the Senate resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The motion is adopted. Senate resolve itself in Committee of the Whole for consideration of general orders, second reading of the bills, and Senator Roberts will take the chair.
We have 2 amendments and a third. Great.
We're going to be in a senatorial 5. Okay, we are back. Will the clerk please read the title to Senate Bill 4?
Senate Bill 4 by Senator Sullivan, Representative Froelich, concerning who may petition a court for an extreme risk protection order.
Senator Sullivan.
Thank you, Mr. Chair. I move Senate Bill 26004 and the committee report from State Veterans and Military Affairs.
To the State Veterans and Military Affairs Committee report. Senator Sullivan.
Thank you, Mr. Chair. We added 2 amendments at the end, and they were both of a technical nature, adding in words and reducing others. Non-really consequential, but certainly well needed to flow with the language. And with that, I ask for an aye vote.
Is there any further discussion on the committee report? Seeing none, the motion before us is the adoption of the State Veterans and Military Affairs Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the committee report is adopted. To the bill, Senator Sullivan.
Thank you, Mr. Chair. I renew my motion for adoption of Senate Bill 26004 on second readings. And
we have an amendment. And while that is getting ready, I forgot, this is our first one of the year, the coat rule is relaxed for everybody in the chamber.
Do you want them in any
all in order. Yeah.
12, 14, 18. So here you go.
There is an amendment at the desk. Will the clerk please read L012?
Amendment L012, amendment the State Veterans and Military Affairs
Senator
Committee.
Gonzalez.
Thank you, Mr. Chair. I move L12 to Senate Bill 4.
To the amendment.
Thank you, Mr. Chair. L12 simply updates the language that is to include it adds a comma, actually, is what it does. And I ask for an aye vote.
Is there any further discussion on the comma? Seeing none, the motion before us is the adoption of amendment L012. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that amendment is adopted. Senator Gonzalez. Is there another? Okay. There is an amendment at the desk. Will the clerk please read L014?
Amendment L014, amend printed bill page
Senator
2.
Gonzalez,
Thank you, Mr. Chair. I move L14 to Senate Bill 4.
to the amendment.
Thank you. It strikes 6 lines of text. I ask for an aye vote.
Is there any further discussion? Seeing none, the motion before us is the adoption of Amendment L014. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that amendment is adopted. To the bill. Oh, one more amendment at the desk. Here it is. Will the clerk please read L019?
Amendment L019,
Senator
amend printed bill.
Gonzalez,
Thank you, Mr. Chair. I move L19 to Senate Bill 4.
to the amendment.
Thank you. This is also technical in nature. It just adds the institutional petitioner language to the language, to a section of the policy, and I ask for an aye vote.
Is there any further discussion on this amendment? Seeing none, the motion before us is the adoption of Amendment L019. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that amendment is adopted. To the bill, Senator Sullivan.
Thank you, Mr. Chair. Last week, we had an exciting afternoon discussing Senate Bill 26004, which concerns who may petition a court for extreme risk protection orders. It was the first time in my over 13 years of activism on the gun violence prevention policy that state police officers had to come into the hearing room to remove somebody there to testify. We had, by my count, 60 different people come to be heard. Over 10% of those individuals used a portion of their time to call me out by name with hostile and threatening comments. These are actions I have come to expect in this policy space, but the anger and the rhetoric is at a new level. I wanted to address some of the other questions and comments made during this hearing. I also am curious to hear what others thought of the proceedings. We heard once again how the actions of House Bill 191177, which is the foundation of Senate Bill 26004, are in some people's minds unconstitutional. The courts have already weighed in on the question. This legislation is constitutional, and saying it's not over and over and over again is not going to change that fact. There were questions about how this legislation would somehow be used to be used maliciously against our citizens. This bill has been in effect for over 6 years now, with less than 3% of the petitions determined to be inappropriately used or falsely filed. All were denied and proper penalties were applied. It was stated that a person's life would be ruined. Let me point out, the word was ruined, if they were falsely accused and temporarily had their firearms removed. We were pleased to see that Johns Hopkins Center of Gun Violence Solutions and the Firearm Injury Prevention Initiative School of Medicine from CU Anschutz came and spoke in favor of the legislation. These are two of the most well-known institutions of higher learning on this subject. The Anschutz campus explained that since 2020, they have had a policy that addresses and reacts to these types of threats. The man who killed my son Alex and 11 others at the theater massacre was a student at the Anschutz in 2012, and no such program existed. I'm hopeful today that I might be enlightened how those who feel concerned of someone's life being ruined felt about those who were impacted on July 20th, 2012. The 12 who lost their lives, the 3 that have been committed to a wheelchair for the remainder of their lives, and several others that I know of who have taken their own lives since then. If we had had the ability to temporarily remove that killer's firearms because he clearly had told the campus therapist he was ready to do harm to others, how would all those impacted had their lives changed? I guess maybe you'll tell me how you think my life hasn't been impacted since that day. We heard questions about the cost. They don't believe the fiscal note, and they had no data to back up their claims. Just like malice and unconstitutionality, if you say it enough times, they think someone will believe it. Teachers, doctors, and therapists were not trained to fill out the forms to file this type of paperwork. That is why it is so important to allow the institutions, hospitals, and others to file, because that's what they were trained for. It's also what they have the time to do. We had a retired school therapist tell us she spent well over an hour trying to navigate the form needed to file a petition. She explained that she is only given 20 minutes, not the 2 minutes that someone came to the podium and testified that that's what she had said. No, she said 20 minutes. She's allowed 20 minutes per student. She noted that she would have had to see 3 or 4 fewer students for each time she needed to file a petition. In Colorado, nearly 40% of petitions are denied because of clerical and unknown reasons. Not because they're not warranted, it's because they were filed in the wrong county. They had an inappropriate relationship, or the wrong type was filed. When we have better people trained in executing the paperwork, we can lower the cost of the process. We won't have to do this over and over again. Cost was also told as a factor for those who may be financially challenged and would not be able to protect themselves and their families. One FFL spoke about transferring ownership for one that I guess was impacted by an ERPO. She told us that that individual had 22 firearms. We were told that each firearm would require first a $10 fee, and then on top of that, another $40 fee, and finally a third $15 fee. No storage was going to be involved in this transaction, but we did hear that storage was $15 a month, and it had to be renewed every 6 months. The number of firearms anyone needs to protect their family or to own is a choice that they make. If you can't afford to own the collection that you have and you need, that's a decision for you. FFLs complain they don't have the room to store people's firearms. Maybe if they didn't continue to display high-capacity magazines that are illegal in this state and change their business plan to storage instead of sales, they wouldn't have that problem. Due process was once again voiced as an area of concern. Again, no data was provided to back up these false claims. But the Bipartisan Safer Communities Act specifically funded the rights for due process, and Colorado continues to be the only state in the country that provides legal representation at no charge to the individual. All petitions filed by healthcare or mental health professionals, educators, and district attorneys between January 2020 and December 2024 have been granted. Research suggests that for every 10 to 15 ERPOs granted, 1 suicide death can be prevented. This is reason enough to vote in favor of this expansion. Data shows that nearly 85% of Colorado adults are aware that ERPOs exist. Even in the 39 of Colorado's 64 counties that have proclaimed themselves a non-binding Second Amendment sanctuary county, they too have filed extreme risk protection orders and had them granted to protect the lives of their citizens. There is data, report, hotlines, efforts to educate the voters of Colorado how effective the extreme risk protection order legislation has been in Colorado. Senate Bill 26004 will further that effectiveness, and I ask for your yes today so we can continue to save lives as this state struggles with the public health crisis that is gun violence.
Further discussion. Senator Zamora Wilson.
Thank you, Mr. Chair. Request a clarification from the sponsors that the amendment removes the healthcare facilities from the bill. That would be
Senatorial 5. And we're back. Is there any further discussion? Senator Zamora Wilson.
Thank you, Mr. Chair. So I was in the committee and we had heard that from the sponsor that this is constitutional because Colorado courts deemed that. And I would like to remind people that they have been known to make mistakes. One example is having President Trump removed from the ballot. That was overruled. So, just as some people claim that this is constitutional, we can also say that it is unconstitutional, and I will keep saying that. So, Senate Bill 26004, a measure that, under the guise of public safety, threatens to expand an already burdensome extreme risk protection order system in ways that will inflict unnecessary harm on innocent citizens. It will strain our taxpayer dollars and erode the very fabric of trust in our institutions. When this bill went through committee, it was said that this bill will have no added costs, which makes no sense because the sponsor says that this bill is going to save lives, which means that there will be an increase in, as we say in economics, demands for ERPOs. This will increase ERPOs, the number of ERPOs, and it will have a cost, monetary, non-monetary, and dangerous unintended consequences. So let's go with the basics of SB 26004 and the purposes. This bill would expand the list of eligible petitioners to include healthcare facilities or behavioral health treatment facilities, K through 12 schools, institutions of higher education, and certain co-responders. On the surface, this sounds benign. Who doesn't want to prevent risks? We all care about public safety, but digging deeper, you'll see there's an overreach that doesn't alter the underlying ERPO process, but amplifies its problems. ERPOs are civil orders that allow for temporary seizure of firearms based on claims that might be false or unsubstantiated. This is by force, people. To be clear, this is at gunpoint. Citizens will have their weapons stripped from them along with their Second Amendment rights to bear arms. So let's look at the unconstitutionality and begin with the Second Amendment. This is the bedrock to our right for self-defense and a bulwark against tyranny. The Second Amendment states plainly, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And by broadening this aperture of who can initiate an ERPO, invites a flood of petitions that could result in the temporary or even year-long seizure of firearms from law-abiding citizens based on mere allegations of risk. These are not convictions. These are civil orders issued unilaterally, often without the respondent even knowing until their door is knocked on by law enforcement. And in the wake of the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin, we must ask, where is the historical tradition of disarming individuals preemptively without a criminal charge or trial? There isn't one. ERPOs, like those expanded here, treat gun ownership as a privilege, revocable on hearsay, not a right. By empowering schools and healthcare providers, entities not trained in legal due diligence, to file these petitions, SB 26004 risks weaponizing personal disputes or biases, stripping Coloradans of their arms without evidence of wrongdoing. This isn't safety, it's infringement, plain and simple. And it compounds with bills like SB 25003, which already bans transfer of certain semiotic firearms, turning temporary seizures into permanent losses. If we pass this, we're not just violating the Second Amendment, we're eroding the very essence of American freedom. But the violations don't stop there. Let's turn to the Sixth Amendment, which guarantees that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury, to be confronted with a witness against him, and have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Proponents of SB 26004 will claim ERPOs are civil, not criminal, so the Sixth Amendment doesn't apply, but this is the distinction without a difference in the stakes, and the stakes are so high. The loss of constitutional rights, public stigma, and potential criminal charges for noncompliance. And under the Colorado's ERPO framework, which this bill expands without reform, temporary orders can be unilaterally be issued, meaning the accused isn't presented to confront their accuser or present evidence. The accuser gets to be anonymous behind the institution. And so if I'm being accused, I don't get to know who is accusing me. No speedy trial, no jury, no cross-examination, just a judge's quick decision based on a one-sided claim from possibly a school administrator or healthcare worker who might have a grudge or misunderstanding. And if the order sticks for 364 days, that's a de facto punishment without the protections of a criminal process. Critics, including the NRA, ILA, have rightly pointed out that these red flag laws bypass Sixth Amendment safeguards, treating respondents like criminals while denying them the rights afforded even to the guilty. And by increasing the number of petitioners, this bill multiplies these injustices, turning civil proceedings into backdoor prosecutions that chill trust in our judicial system. How can we call this America when it echoes the star chambers of old? Now on to the 14th Amendment, which declares that no state shall deprive any person's life, liberty, or property without due process of the law, nor deny any persons within jurisdiction the equal protection of the laws. Here, SB 26004 expansion strikes at the heart of due process. Temporary ERPOs up to 14 days can be granted without notice or an opportunity for the respondent to be heard, leading to immediate firearm seizures that disrupts lives. They also disrupt livelihoods and safety. If I'm being accused and I have to wait up to 364 days as not a big, beefy person, I am losing my right to defend myself. There is a cost to that for me. This is not due process. It's presumption of guilt. And in America, we are innocent until proven guilty, but in this case, we are not. The 14th Amendment demands fundamental fairness. Yet under this bill, new petitioners, like behavioral health facilities, could file based on vague or unsubstantiated claims, disproportionately affecting rural gun owners or those in the Second Amendment areas that have a Second Amendment sanctuary, where counties' enforcement is already uneven. And so we have equal protection. Hardly. Studies and legal challenges highlight how ERPOs can target marginalized groups or political minorities with no robust mechanism for appeal or expungement in Colorado's law. The emotional toll, stress, stigma, loss of work deprives liberty without adequate safeguards. And when false petitions arise, as they inevitably will, with more filers, respondents face lawsuits or perjury pursuits that rarely yield justice, all the while taxpayers foot the bill for court times and defenses. This bill doesn't enhance safety. It undermines the procedural protections that make our republic endure. And then we get into the economics. Again, it was said that there are no costs. When we were listening to the testimonies, there was several people that were highlighting that there will be costs, and I'll highlight some of them here. There are both monetary and non-monetary costs that'll be on the taxpayer, but also those that, if I'm being accused and I'm innocent, you have those false claims and that's going to incur costs on those that are innocent. So consider the plight of a Coloradan that's falsely accused under this expanded system. Imagine you're a law-abiding citizen, your child goes to their teacher, and for whatever reason, the teacher highlights that there's a concern and files an ERPO on me. Someone who is not trained in this arena, but now I'm slapped with a temporary ERPO lasting up to 14 days or, like I said, 364-day order. What are the monetary costs? Well, it's said that the defense lawyer will be free. The state will pay for it. Where does the state get the money? From the taxpayer. That's another topic, but let's continue on with me. I may not want the defense lawyer from the state because I want a really good lawyer, so I'm going to pay for that. And of course, there's fees. We could talk about $2,000 to $5,000 or more if you hire a private attorney, and while the court appoints, I've already mentioned that. So that's real money out of the pocket for me, a person who's innocent, who has done nothing wrong. And there was mention about the gun storage. Yes, we have gun storage. You have to surrender your firearm to law enforcement. It's free, but is it free? There's no such thing as a free lunch. That could be, again, to the taxpayer. But if you choose a licensed dealer, you're looking at $20 to $50 per month per firearm. And for a 14-day turbo, that's $50 to $100. And for a full year, it's $200 to $600 or more. And we have renewal fees for things like concealed carry permits, another $50 to $100 hit, plus background checks, ATF form 4473 in those checks. So 10 to 25 each time you try to buy replacement or navigate the system after the ERPO. But wait, there's more. It gets worse when we factor in other bills like SB 25003, which prohibits the transfer, sale, or purchase of certain semi-automatic firearms, which started on August 1st, 2026. If an ERPO hits you before that ban, you could lose the ability to sell your firearm. So we're talking about the resale value of $500 to $2,000 per gun potentially wiped out because your property becomes non-transferable. The compounding effect just isn't theoretical, it's a direct negative impact that SB 26004 exasperates by increasing the sheer number of ERPOs filed. So now let's pivot to the non-monetary costs, which are often the most insidious. Time without your weapon for self-defense. I already mentioned that. That's a profound loss to me, with especially my statute. And it's also for those in rural Colorado where help might be miles away, or in high crime areas where vulnerability spikes. Emotional and psychological stress from false accusations, that can exasperate mental health issues, strain relationships, and lead to therapy needs that aren't covered. How about time in court? Hours upon hours, 2 to 8 per hearing, plus preparational and travel, disruption to work, family, and life. And the stigma? ERPOs become public record, affecting employment, housing, social ties. No expungement process in Colorado law means this black mark lingers. You can't hunt, recreate, or participate in gun-related communities. These are lost opportunities, social isolation, and what about professional licenses, jobs involving firearm or security clearances, all at risk from indirect discrimination. And in my area, we have 5 military bases. Our clearances are very important to us in achieving our job. This would impact my area greatly. So let's broaden the lens of the costs borne to us. The taxpayer. Again, this was said that there's no cost, but let's look at it in the view of the taxpayer. SB 26004 is expected to increase ERPO petitions. The sponsor said this was going to save lives. That means there's going to be a demand in economics, supply and demand. So there's going to be an increase in demand of ERPOs. So naturally, there's going to be increases in costs. Based on expansions like SB 23170, which added similar groups, we saw about a 5% increase of petitions from those in new categories, with baseline filings around 140 to 170 annually. We're looking at 20 to 40 more cases per year, a 10 to 20% bump. The official fiscal note claims minimal state revenue increases and workload hikes starting in fiscal year 26 through 27 with no new appropriations, but a deep dive reveals the truth that there's going to be compounded costs from unintended consequences that could run into the hundreds of thousands annually. How about judicial workload and staffing? More petitions means more hearings. So for temporaries, we have full ones within 14 days. Baseline costs are about $140,000 a year. Add another $10,000, $20,000 for the extra cases, potentially needing more FTEs, especially if the backlogs grow. Court-appointed defense lawyers, about 50% of cases use them at $1,000 to $2,000 each, baseline about $50,000 yearly. But expansion could add $20,000 to $80,000 if false accusations rise, which I would forecast that they will, especially in this arena that we are in, where we as a state are facing we're in a politically divided environment with different ideology, and it seems to be getting worse and worse. And what about law enforcement time? Serving orders, seizing and storing guns? I don't know, 2 to 4 hours per officer at $200 to $400 per case, baseline costs of $239,000 a year, and we'll add $5,000 to $15,000 with more petitions plus overtime in busy areas. Gun storage management, minimal per case, but with SB 25003's bans, with that ban, more long-term holds or destructions could tack on another 1,000 to 5,000 statewide. And now we have lawsuits from falsely accused reports. False petitions lead to perjury charges, but respondents sue for malicious prosecutions. Each defense costing $10,000 to $50,000. And if 2 to 5% of petitions are baseless, that's about $50,000 to $200,000 annually, especially with new petitioners like school and healthcare facilities prone to misuse. And we also have an increased demand for ERPOs. Administrative costs, baseline, add $100,000, add $10,000 to $30,000 for training, compounded from SB 25003. That bills $6.8 million in enforcement costs for fiscal year 2025 through 26, intersect with ERPOs, leading to more compliance checks, storage, and disposals. Another $5,000 to $20,000. Public education campaigns, $20,000 to $50,000 more to train these new groups, reducing misuse but adding upfront burdens. Now let's look at the non-monetary costs to the taxpayers. They're equally alarming. We have time in court, creates backlogs, delaying other cases like family law or evictions, a strain on local governments, small departments in remote areas, or shall we say those that uphold the Second Amendment. We will face uneven enforcement, wasting resources on denied petitions. There also is an unattended chilling effect, where the fear of ERPOs from healthcare or schools deter mental health seeking or education access, leading to higher long-term public health costs, untreated crisis, hospitalization, all on the taxpayer's dime. And I will add a note, in the military, when we have our security classifications, and if someone needs mental help, it was widely known that many military members would not go and seek mental help for fear that their clearances would be pulled. This is exactly what I'm talking about here. How about potential for ERPO violations? More orders mean more risk of misdemeanors, adding court and law enforcement time without offsets, erosion of public trust. This state will be divided. This expansion will deepen rifts. It will reduce law enforcement's community cooperation and fuel political backlash. So I've only scratched the surface, but I want to just emphasize total added monetary costs to taxpayers could be up to $100,000 to $400,000 yearly, on top of the baseline of $500,000 for the ERPO program. And these aren't just numbers, they're dollars diverted from roads, schools, and real safety measures. False ERPOs don't just harm individuals, they foster distrust, weaponize institutions, and compound with other laws to create a web of overregulation. SB 26004 isn't reform, it's regression. It invites abuse, burdens taxpayers with judicial backlogs and lawsuits, potentially we're facing up to $400,000 more annually and divides our state further. And who is this going to impact the most? Who is going to feel the consequences of this? If I'm falsely accused, think of all those people. It's going to impact women and minority. We will be stripped of our ability to defend ourselves. It's going to hit the low income. You think the $15, $10 is no big deal, but you add up this and the monetary costs, the non-monetary costs, our low income people are going to suffer. Our fixed income people are going to suffer. This is not a good bill. We must reject it. We must uphold the Constitution. I swore an oath to uphold the Constitution. I urge you to uphold and defend the Constitution. I ask for a no vote. Thank you.
Further discussion? Senator Pelton.
Thank you, Mr. Chair. I had the privilege of sitting in committee and listening to this bill last week. In my opinion, there are many concerns around this bill. The good senator from the Air Force Academy did a good job of pointing some of those out. I'm just going to kind of put my little take on it. You know, comes to due process around the whole ERPO topic and this bill in particular, it strips that away. The accused does not get to face or know who his accuser was. They're hidden behind an institution. That's not right. That's not America. In America, we have that right, and we should be able to exercise it. This bill prohibits that. There will be many constitutional challenges. You know, it was stated in committee that the original ERPO bill passed in this court in Colorado. Well, the 10th Circuit is not the United States Supreme Court. I feel that that bill will have a tough time passing the United States Supreme Court. I worry about how this bill will intersect with Senate Bill 25003, which was passed last year. We don't have any idea what that intersection will be. If a person's firearms are confiscated and put into storage, and then when they come out of storage, now all of a sudden that person has to go get all the training just to get their rightful property back, I have a problem with that. The sponsor suggests that gun stores maybe change their business model to storage instead of sales. I would argue a lot more money is made in sales of firearms than in the storage. That type of storage isn't cheap. And then we get to the HIPAA part of this bill. I think with health and medical or mental facilities being able to issue or ask for ERPOs, it'll have a huge chilling effect. Erosion of therapeutic trust with people that might go in seeking help with their professionals. It just opens it up. Institutional surveillance can come about. This bill is ripe for challenges and so many fronts, and HIPAA being one of the biggest. So with that, I urge a no vote on 004.
Senator Pelton.
Thank you, Mr. Chair. So one can appreciate the discussion that we had, or the presentation from the good senator from Centennial up here, was when we were talking about institutions filling out the proper paperwork. One can appreciate that, especially with the burden of big bureaucracies that brings with the paperwork. I was in the military myself. I remember how much paperwork I had to fill out. And so that's definitely something that one can appreciate on that aspect. However, doesn't the accused have the right to face the accuser? Isn't that a fundamental right that we have under our Constitution? The reason why I bring this up is that we've passed things in this chamber and in this building that has been challenged, and at to what cost? Perfect example, I think it was last year or maybe even this summer, when the abortion pill reversal that was reversed, and now the state has to pay $6.1 million. What does that do to our budget? These are things that we need to think about. This is the debate that we're having right now, is to make sure that we don't want to do that. And this debate matters. These questions need to be asked. So therefore, I'm going to have an amendment here.
There is an amendment at the desk. Will the clerk please read L001?
Amendment L001, amendment
Senator Pelton.
Thank you, Mr. Chair. I move L001 to Senate Bill 004.
To the amendment.
What this amendment does is this amendment ensures that the recipients of the ERPOs have the right to know who their accuser is. Currently, the bill allows for institutional petitioners to seek the ERPO, essentially allowing accusers to hide behind their employer. This level of an autonomy contradicts with the Sixth Amendment right. By allowing institutions to file ERPOs, the recipient of such an order could have their Second Amendment rights stripped without even knowing who their accuser was. This amendment guarantees that the nefarious individuals or past abusers cannot hide behind institutions to unfairly strip Coloradans of their Second Amendment rights. So that's why I'm asking for this amendment. This is going to be the first one of our amendments over here, and I just wanted to really focus on that aspect, that they should have every right to attack or know who their accuser is. So I ask for an aye vote on L001.
Further discussion on the amendment? Senator Bright.
Thank you, Mr. Chair. I rise in support of Amendment L001, Senate Bill 4. I believe that the spirit and the legal standing, the legal statement within the U.S. Constitution, especially the Sixth Amendment to the U.S. Constitution, talks about how important it is for us as accused to know our accuser. And I feel like Senate Bill 4 works against the Sixth Amendment to the Constitution and allows accusers to hide behind institutions or entities and be able to make claims potentially baseless. And so I feel like those folks who are making those claims, those accusations should live by the Sixth Amendment and be able to address those charges. So again, I rise in support of Amendment L001 to Senate Bill 4.
Senator Carson.
Thank you, Mr. Chairman. I would also like to speak in support of the amendment by the good senator from Morgan County. And the important principle here, of course, is that you be confronted by your accusers. And what the amendment does, the amendment states that if an institution requests an extreme risk protection order, the identity of the institution's member who initiated the ERPO must be made available to the public. This amendment ensures that the recipients of ERPOs have a right to know their accusers. Currently, the bill allows for institutional petitioners to seek an ERPO, essentially allowing accusers to hide behind their employers. This level of anonymity contradicts the Sixth Amendment rights of every Coloradan. By allowing institutions to file ERPOs, the recipient of such an order could have their Second Amendment rights stripped without ever knowing their actual accuser. This amendment guarantees that nefarious individuals or past abusers cannot hide behind the institutions to unfairly strip Coloradans of their Second Amendment rights. So I think this amendment gets to an important distinction in where we've been historically with these ERPOs. When you bring in the veil of an institution, whether it's a hospital, healthcare facility, a school, a public school, including a charter school, other institutions which can file for these ERPOs with a great deal of anonymity, you clearly you run afoul, potentially at least, of the right to be confronted by your accuser in the Sixth Amendment in the U.S. Constitution. Now, the senator from Centennial, I think, has made a lot of comments about constitutional questions, and I will certainly acknowledge that in these areas there's a lot of dispute about what's constitutional and what isn't constitutional. But I would also submit that just because something might be constitutional certainly doesn't mean it's good policy. And I think a bedrock principle of our system, of our legal system, is that a person has the right to know who their accuser is. I mean, these ERPO filings should not be taken lightly. I mean, a person is being accused of something that warrants legal intervention, judicial intervention, scrutiny by the public, potentially a good deal of questioning and shame coming on that person as a violent individual, as a danger to the community. And so I don't think it should be taken lightly, this whole question of being accused anonymously by someone you don't know, that you cannot confront, that you cannot have a response to through the judicial or legal process. So I think the senator's amendment is an important amendment. I think it's certainly something that we should be concerned about in any kind of legislation of this nature, that we not cross that line, that we begin to raise some serious questions about due process. Because due process is the very fundamental principle of our legal system. I will also later have an amendment to this bill, but I think on this amendment, what we need to talk about is the history of due process under English common law, going all the way back hundreds of years. Basically, the principle that the king, the sovereign, the government cannot just randomly accuse a person of a crime, cannot round up people without due process. And of course, the principle putting in writing that the person has a right to due process, to things like being confronted by your accuser, to be judged by your peers, to have the full benefit of the legal system, to respond to accusations in public, to know who what you're being accused of and who is accusing you. And it goes all the way back to the Magna Carta and the English Bill of Rights and our own Constitution. This process of this principle of due process. Today in our U.S. Constitution, of course, it is embedded in the Sixth Amendment to the Bill of Rights. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So these principles of due process date back many, many hundreds of years through English common law, of which our United States Constitution is based largely upon. And so I'll just make the point again, we can have endless debates about whether a particular new statute or provision passed by the Colorado General Assembly is quote-unquote constitutional or not. Initially, it's going to be presumed as constitutional, and then it'll go to the courts, may go to the state courts, it may go to the federal courts, may ultimately go to the U.S. Supreme Court. And I suppose ultimately that is the forum by which we determine whether something is constitutional or not. But to me, I think it's important to make the point that we not stand here and just constantly say, well, if something is potentially constitutional, it's good public policy. I certainly don't subscribe to that notion, because to me, if you're going to be accused of being a threat to the community, of being a violent person, of being someone who would engage in the type of horrible actions that we've unfortunately witnessed in our state a number of times, way too many times. One time is way too many, but if you're going to be accused of that, I think we have to adhere to a fundamental principle of our legal system, which is that you be aware of who your accuser, who's accusing you, what an institution under this bill essentially can accuse you of falling into this category. I understand, certainly, I think many of us understand the thinking, at least one of the reasons for this legislation. There may be a number of reasons for this legislation. I mean, clearly, we have a mental health crisis in this state. I think the causes, the roots of these horrible crimes are generally traced to mental illness of some type. And so I do think, though, we have to be careful when we set up a system where virtually, anyone can be accused, I suppose, by an institution. You could be in a dispute. A parent could be in a dispute with a school administrator. A patient or a family member could be in a dispute with a healthcare institution. Maybe says something inappropriate. And then this mysterious process comes about where you're accused of being a threat to the community, and you have no idea who's accusing you of that, and you're just put in the position of having to defend yourself against an anonymous accusation. I think that's a dangerous road to go down. I think it's a dangerous precedent for us to set here. And so I think, again, I think this is a good amendment. I would urge my colleagues to support the amendment so we can keep in place one of the bedrock principles of due process under our system of government. Thank you, Mr. Chairman.
Senator Liston.
Thank you, Mr. Chairman. Members, I too rise in support of Amendment L001 to Senate Bill 4. Appreciate the good words from the good senator from Douglas County. He speaks much more eloquently and probably more knowledgeable. But as I think through this, just as a regular citizen, I am really bothered by the fact that what this bill does is it's institutionalizing, hearsay accusations, whether it's coming from a school or an educational institution or a healthcare, is that we're now pitting citizens one against the other. That just because somebody may be upset with what somebody has said one day or 1 week, or there's an argument, they say, hey, I understand that Joe has said something about a firearm, so I am going to, as an educational person or a person in the healthcare field, all I have to do is, through the institution that I work at, is to say Joe is a threat because he has a firearm, and I supposedly heard Joe say this. And suddenly, people are knocking at the door, the authorities are knocking at the door of Joe saying, we're here to take your firearms. And he goes, well, what have I done? Who says this? Well, we can't tell you. You don't know. In fact, we may not even know, but we heard it through this institution, and we are here to take your firearms. But what have I done? Well, you really haven't done anything, but this accusation has been made via the hospital or the school, and under this law, we're required to take your guns, your firearms, of which, you've done nothing wrong, but we're making this, someone has made this accusation. But I don't know who did it. What did I say or do? It doesn't matter. The law says, under this Senate bill that was passed back in 2026, that we're here to take your firearms. And the person goes, but as a good senator from Douglas County was saying, there's due process. Well, that's too bad. This law, usurps that, what's ever happened. And also it's been brought up before, and I'll say it again, is that clearly, it's already probably been stated in the testimony on this bill, this piece of legislation, should it be passed, is going to be litigated to the nth degree. There are going to be people and organizations and citizens groups that are going to litigate this all the way probably to the U.S. Supreme Court. So we're spinning our wheels for something that, at least in my humble opinion, will probably be ruled unconstitutional because of due process. And also in my district, here over the last 2 or 3 weeks, there's a lot of petition process going on for various candidates in El Paso County clerk and recorder, the sheriff, the treasurer. There's a whole multitude of candidates that are petitioning to get on the ballot, and I've been out there helping them, knocking on people's doors in my district, because people do know me. And, people are a little more attuned now that we're back in session. Well, Larry, Senator, what's going on in the legislature? Well, I tell them about some of the different bills, but quite frankly, colleagues, nobody, and I'm not exaggerating, nobody has brought this up to me. Gosh, we need, this bill, Senate Bill 4, we need to institutionalize and give the power of authorities to take away people's firearms. Nobody brings it up. It's not on their radar. They're not concerned about it. They're more concerned about crime and safety and the so-called affordability and fixing our schools, fixing our roads. This isn't on people's radars. Why are we going after the law-abiding citizens who have done nothing? They've done nothing wrong. What I did hear, and I'll read you part of the text, what I did get is a phone call, though, from a Mr. Hayes. I won't say his full names, but he says, hey, this is in violation of my constitutional rights, and I'm going to cancel my VA appointments. I'm a disabled veteran. The current red flag laws in Colorado violate U.S. section, and he goes on through to say, Section 18 U.S. Code 241, Conspiracy Against Rights Acts in violation of the Americans with Disability Act, and so forth and so on. I called this gentleman back, one, just to let him know that I heard his phone call, and I hear his concerns. The law of unintended consequences is definitely going to occur with this, because here is a veteran, a disabled veteran, who he admits that he might have some mental issues, but he said, what I'm going to do, I am not going to see my doctor. I'm not going to go to the VA hospital, because I am now afraid that if I should go, because whatever his mental issues might be, whether they're severe or not, he seemed very logical and cogent to me. He wasn't angry. He didn't give the idea that he was ready to go ballistic or anything. But he said, I am concerned. So the safest route for me to protect my Second Amendment rights is that I will not go see a doctor that I may be or a medical professional at all. So there's going to be other people that are going to be like this as well. So I think the good senator from Morgan County, I believe I have that right, Logan County. I knew it was I take that back, a good senator from Logan County, that he's right, he's spot on, is that the people should have a right to know who is making these accusations. That's true for anything. So this is a good, well-crafted amendment, and it will make a bill like this better and more palatable. I would encourage the members, at least those who are here in the body right now, there's a lot of vacant seats right now if you only knew, but anyways, this is a good amendment. I would urge an aye vote on Amendment L001 to Senate Bill 4. Thank you, Mr. Chairman.
Senator Rich.
Thank you, Mr. Chairman, and I certainly rise in support of Amendment L001, brought by the good senator from Logan County. Anonymous accusations, I was thinking about that. I thought, in all the time that I worked in a federal court system, I don't think we ever had a case where they accepted anonymous accusations. And here we are. This amendment seems reasonable, that you should have a right to know who your accuser is, especially if you're found to be not guilty of what they have accused you of. You ought to be able to recoup the damages that something like this has created. And so I don't have a whole lot to say about this, except that it bothers me that accusers can hide behind employers. I guess with an institution, any of us could hide behind the Colorado General Assembly and file an ERPO on anybody in this room, just based on something they may have heard in the elevator. So I appreciate L001 and ask for your aye vote.
Senator Frizzell.
Thank you, Mr. Chair. Members, I have heard a lot about this bill from my constituents, just simply because in Castle Rock and Parker, Second Amendment rights are a big deal, a really big deal. And I am here to stand in favor of Amendment L001. But I also wanted to ask a question that I'm getting a lot, and that is, I'm asking the bill sponsors, can you please help my constituents at least understand why, what is the purpose behind including institutions as an entity or a person that can, it's included in the definition of community member, that can request an extreme risk protection order. So I'm asking on behalf of my constituents, why are we doing this? What problem is it that we're trying to solve with this particular legislation? That's a question. So I'm asking a question of the bill sponsors. What is the purpose of...
Opening statement. You can go back and read the opening statement. It's all there.
Okay. All right. With that, I will ask for an aye vote on L001, and I'll be back.
Further discussion on the amendment, Senator Zamora Wilson.
Thank you, Mr. Chair. I rise in support of L001, Amendment L001. I believe that when we are able to face our accusers, what this is going to do is mitigate those false allegations that I was really concerned about. You will have those that are filing the ERPAs will have skin in the game and verifying that this truly is a concern, and if they're trying to save a life, it'll be no problem to be known. I urge a yes vote for L001.
Further discussion on the amendment? Mr. Minority Leader.
Thank you, Mr. Chair. Thank you to the sponsors. I rise in support of L001, and it kind of gets to a challenge I see in the language of the bill. So really, the heart of the bill is under 1314.5103, temporary extreme risk protection orders. A family or household member of the respondent, a community member, and now we're going to add an institutional petitioner or law enforcement agent, officer or agency may request this order. So we're adding this institutional petitioner. So if we scroll back into the definition of the institutional petitioner, institutional petitioner means an entity that employs or contracts with a community member. So now I go back and say, all right, so there's definitions of what a community member is. It's a licensed healthcare professional or mental health professional who, through a direct professional relationship, provided care to the respondent or the respondent's child within 6 months before requesting the protection order. Then we struck, through an amendment on second reading, the next section, and then it includes an educator, and we're adding a co-responder, and then a definition of educator. But my challenge in this space, and the reason I'm supporting the petition, the institutional petitioner means an entity that employs or contracts with a community member. There's like no direction that says the request for the extreme risk protection order has to originate with a community member. It just says they just have to work for us. It allows the institutional petitioner to file on behalf. I would hope we would give some direction and guidance and requirements that institutions must construct rules, I guess, and regulations, as much as I hate to see more rules and regulations, but what drives the institutional petitioner to file the request? Under the current definition, it just says you have to employ a community member. That's the only requirement. I think if we at least included a requirement that that request had to come from a community member, and then it's really important to add a full transparency to identify where that request came from and who the community member was, it would bring more clarity to this discussion. And I think incrementally reduce the potential for abuses. It's a simple request to have the individual community member identified and required by the institutional petitioner that the request came from a community member. For those reasons, Mr. Chair, I rise in support of L001.
Senator Gonzalez.
We're talking about Amendment L001 to Senate Bill 4. Now, the Minority Leader correctly cites to Title 13 to find the statute that pertains to the original extreme risk protection order law that was passed and enacted. And I wanted to hear the debate from the opposition, because I was hoping that perhaps one of the members from the minority party might actually delve past the black letters on the white paper of both L001 and SB4 in and of itself. But that doesn't seem to be the case, so that's cool. Follow along, friends. We're gonna do a little bit of Schoolhouse Rock here. Let's go and Google ERPO Forms Colorado. That's gonna bring up on the first link available in the Colorado Judicial Branch, that's gonna bring up the forms. The first link that is available there is JDF 572, ERPO instructions. Click on that. That brings up a form that is both available in English and Spanish. It walks through all of the step-by-step instructions on how to actually go about and fill out an extreme risk protection order. Now, I will say that on the first page of the instructions, it says, if you do not understand this information, please contact an attorney. And from the good senator from Monument? From, well, what town? You live? Well, for the good senator from El Paso County, she said that up to $5,000 an hour that an attorney may charge in order to help a respondent navigate these types of situations, which, again, the state will also provide legal representation pro bono and at no charge. Now, the second link that one would click on when looking at these forms are the actual motion. Is the actual petition and affidavit for both a temporary and an extreme risk protection order. I'm going to instruct y'all to go to JDF 573, the petition itself, because at the end of that document, page 5 of 5, I declare under penalty of perjury under the law of Colorado that the foregoing is true and correct, executed on date, at location, printed name, and signature. Friends, L001 is redundant and not necessary because the form that would be utilized in order to file an ERPO, even contemplated with an institutional signer, still requires the name and signature of the person filing it. I ask for a no vote.
Further discussion on Amendment L001. The motion before us is the adoption of Amendment L001. A division has been requested. We will be in a senatorial 5. And we are back. Yes. A division has been requested on Amendment L001. All those in the chamber not entitled to vote, please be seated. The motion is for the adoption of Amendment L001. All those in favor, please stand. Please be seated. All those opposed, please stand. The chair is not in doubt. Amendment L001 is lost. Senator Frizzell.
Thank you, Mr. Chair. We've talked a lot about due process this morning, and I think it's incredibly important. We talk about it a lot on a daily basis, whether it is a situation like an ERPO or immigration policy or literally any type of legal act, because that's due process is at the core. It's a foundational concept in the United States of America. And it's foundational because our founding fathers decided that they needed to do things differently than maybe other countries. They needed to make sure that citizens were protected from a government that took arbitrary and capricious actions against citizens. It says that the government has to follow fair and legal procedures. It says citizens have the right to be noticed, that they have to be informed if they've been accused of something. They have the right to a fair trial. We talked a lot last session about speedy trials. Due process also has a presumption of innocence, and it protects everyone. Everyone in the United States of America, regardless of their legal status, has the right to due process. I know. When we talk about, and we've talked a lot already, about this idea that someone can hide behind the corporate veil, that's what this bill does, and I very much appreciate the excellent education from the good senator from Denver on what exists in forms today. But today's law, as it stands regarding ERPOs, really pertains to individuals. It does not pertain to institutions. It doesn't pertain to corporations. Who it pertains to has been very clearly spelled out. And in fact, people who work in the healthcare industry already have the ability to come forward. They already have the ability to come forward and say, this patient that I'm seeing has issues. I'm concerned about their safety and the safety of those around them. They have that ability. Teachers or people who work in schools already have the ability. Faculty members at an institution of higher education are already in statute. These folks are already there. So what we have included, though, is this concept of institutional petitioner. And my guess, not an attorney, don't work for the Department of Law, but I'm guessing that somehow we're going to have to alter these forms and accommodate this new entity called an institutional petitioner. And, you know, obviously an institution isn't going to be signing a document in and by themselves. It takes a human being to do that. I'm guessing a registered agent or somebody who is in charge of executing legal documents on behalf of that institutional petitioner. That's going to be a person or persons. And is it really fair for that person or persons to who may or may not even be related? They may not even be part of this petition. They're just doing it because it's their job. So I'm kind of confused that we would include, and I'm sorry, I was listening to opening remarks, and I understand that Johns Hopkins, who is not doing business in the state of Colorado, was certainly part of that conversation. But anyway, so given our previous conversation, I would like to submit an amendment.
There is an amendment making its way to the desk. Mr. Schaffler, please read L3.
Amendment L3, amend printed bill, page 4.
Senator Frizzell.
Thank you, Mr. Chair. Your voice changed, so you must be a different person. Welcome back to the party. Mr. Chair, members, I would like to move Amendment L003 to Senate Bill 004.
To L3. Senator Frizzell, go ahead to L3.
Thank you. So, members, this amendment states that if an institutional petitioner requests an ERPO, the request must be endorsed by at least 3 members of the institution itself. This really, it works to thwart some of the things that we talked about in the last amendment, which is, you know, we want to make sure that bad actors or people who do not intend well, I wouldn't want to characterize anyone's motives, but there are people who make false accusations, and they can especially feel emboldened to make false accusations if they can hide behind an institutional petitioner. So this makes sure that those bad actors can't single-handedly weaponize institutional ERPO petitions. This is those, ex-boyfriends and girlfriends, family members who maybe you all get along with every member of your family, but not all families are like that, and some of them can be very spiteful. You can also have colleagues who are politically imposed, or they want to get their employers to spearhead ERPO petitions just because it's on their behalf. So by allowing institutions to file ERPO petitions, the recipient of an ERPO may never know that someone who they have a relationship is actually the true originator of the order. Because again, there's a person who is going to be signing the petition on behalf of the institutional petitioner. We had that conversation just a few minutes ago. Someone has to sign the petition, but who that person is somebody who is likely not having anything to do with the reason for the petition. I think that this is a really good compromise on this matter, because this amendment really just requires these 3 individuals to sign an affidavit saying, this is really important. We agree with the person who, or people, bringing this petition forward saying, we have a problem with John Doe and their firearms must be confiscated. While I don't agree with the premise, I think that this particular guardrail will really ensure that people who might abuse the system cannot just unilaterally push for an unwarranted ERPO. I have a few other comments that I would like to make about this from the framing of who should be doing this. This is the thing. People in the healthcare industry are hopefully trained, especially when it comes to mental health, that they are trained to understand when someone is a risk to themselves and to others. They already, because of existing law, have the ability to file a petition to seek help for this particular individual. They have that already. Teachers, if they see a kiddo in their class who's struggling, they have the ability. I just have to say that institutionalizing, bringing the University of Colorado or Colorado State University or one of our higher education institutions, whether it's a community college or a four-year college or whatever it is, or a trade school, into this conversation, it feels to me that we are creating another layer that is completely unnecessary and also ambiguous. We continue in the state of Colorado to play what I would characterize as whack-a-mole with people's gun rights. But we're not addressing the issue. Why are we having this conversation to begin with? Because we have people who commit crimes with firearms, with knives, with lots of different instruments, because they are mentally ill. We have yet to even begin to address that issue. I don't know about any of the rest of you that got to sit through the Health and Human Services SMART Act hearing, where we heard from BHA and the myriad of other organizations that have devised different programs around mental health. But I don't feel like it's very successful. This is a big reason why we keep having these conversations, but we're not solving anything. We still have gun violence, not just in Colorado, but around the country. As a nation, this is a fundamental issue that we must begin to address. So meanwhile, we schlep hundreds and hundreds of millions of dollars to BHA without demanding any accountability. But by golly, we're going to take away somebody's Second Amendment right, because that will solve the problem, which, oh, by the way, it's not. I ask for your aye vote on Amendment L003.
Members, the question is L3. Senator Wright.
Thank you, Mr. Chair. I rise in support of Amendment L003. I believe there's a wealth of discernment, a wealth of knowledge in numbers. I feel like the subject matter that we're talking about is removing someone's right to be able to protect themselves. And I feel like that's really serious territory that we're treading on. I know that there is the potential for some bad actors. There's some potential for revenge on an individual basis. There's potential for misuse of a clause like this. And I would want to make sure that more than one individual is present so that folks could be held accountable for personal vendettas that they might have. I feel like this is healthy. I feel like with the territory that we're at, removing the U.S. the rights of a U.S. citizen should be considered very carefully, and I feel like having a committee of 3 to do this shows some checks and balances. I mean, there's a reason that our government is not run by just one individual, as we might debate, but 100 of us, because there's wisdom in numbers. And so I feel that that it's important to have a number of voices at the table while we're considering someone's right to defend themselves. So again, I would encourage a yes vote on Amendment L3.
Senator Zamora Wilson to L3.
Thank you, Mr. Chair. I rise in support of Amendment L00. Are we on 3? 3, 4?
Question is L3. Yep, go ahead.
Okay. I think this is really important to bring accountability. And again, my concern is false ERPOs being used. And if you mitigate that and reduce that number, we will see a savings in taxpayer dollars. I also believe that'll increase justice. And one thing I want to tie in, even in the Bible talks about if it requires a testimony of 2 or 3 witnesses to establish a charge, a sin, or any accusation against someone, preventing conviction based on a single person's word. And this principle ensures justice. It protects against false accusations, as I stated before, and is applied to legal matters and also church discipline. So in Deuteronomy 19:15, it states that one witness is insufficient to convict someone of any crime, sin, or wrong, and a matter must be established by 2 or 3 witnesses. In Matthew 18:16, Jesus instructs that if a brother sins, taking 1 or 2 others along ensures that every charge may be established. This brings principled and justice. These rules are established to ensure a thorough investigation and to prevent malicious false accusations. And again, this can save the taxpayers' funds in reducing these false ERPOs. I urge an aye vote on L004. 3.
Yeah, members, as a reminder, the question is L3. Senator Baisley, go ahead.
Thank you, Mr. Chairman. I support Amendment L003. I think it's a very reasonable approach to trying to, if not unmask or identify the individuals, at least get some folks cooperating with the notion of submitting that ERPO through the institution, so that it's not just a temptation that someone who might do that for any kind of personal vendetta and so on. I think it's just a reasonable idea. Also, it occurs to me that the institution can easily be used as a mask to cover the person, and it just ironically It was passed this morning, before this, a resolution that includes the words, whereas the use of masked or unidentified personnel in civil immigration enforcement represents a form of de-individuation that has the likelihood of members reasonably fearing the institution. So along those lines, I think it makes sense that we not mask the folks too much, and let's allow multiple people to sign on through that institution to validate the reasonableness of a red flag order. So thank you, Mr. Chairman.
Is there further discussion on the adoption of L3 to Senate Bill 4? Senator Sullivan.
Thank you, Mr. Chair. I ask for a no vote on L003.
All right, further discussion. Senator Gonzalez to L3.
Thank you, Mr. Chair. I appreciate this discussion regarding L3, and we'll just add to the comments of my co-prime sponsor that the concept of being able to confront your accuser is a concept that exists in criminal statute and not civil law. And so I will remind my colleagues from the minority that an ERPO is a civil matter, not a criminal matter, although falsely submitting one of these ERPO petitions does carry with it criminal penalties. And so with that, I ask for a no vote on L3.
Is there further discussion? Seeing no further discussion, the question is the adoption of L3 to Senate Bill 4. Division has been requested. Members, we need everybody back in the chamber. All right, members, as a reminder, the question was the adoption of L3 to Senate Bill 4. A division had been requested. On the question, therefore, all those in the chamber not entitled to vote, please kindly be seated. All right, close enough. All those in favor of the adoption of L3 to Senate Bill 4, please stand and be counted by the staff. Okay, please be seated. Now, all those opposed to the adoption of L3, please stand. All right, the adoption of L3 to Senate Bill 4 fails. Back to the bill, Senator Danielson.
Thank you, Mr. Chair. I rise in support of this measure. I'm a mother of a preschooler and a third grade child in our public schools. And it's always striking to me to have to read the statistics. What is now the leading cause of death amongst young people in this country? Is it cancer? Is it automobile accidents? No. The leading cause of death amongst minors in the United States is due to firearms. 58% of all suicides in the United States are due to firearms. Already this calendar year alone, the United States has had 36 mass shootings. That's more than one a day. 6 school shootings in 1 month. They're so frequent that we don't hardly bat an eye when we hear the news. I know what the people of the state of Colorado want. They want us to stand up and do what's right and protect the young people in our schools and the people in our healthcare systems and do everything we can to address the public healthcare crisis that is gun violence. Giving people in these institutions the tools to face this crisis is just plain common sense, and it is what the people of the state of Colorado are demanding of us right now. I applaud the efforts of the sponsor, and I stand in strong support of Senate Bill 4. Thank you.
Thank you. Further discussion, Senator Pelton.
Thank you, Mr. Chair. When I got up with my opening remarks, I stated I'd sit in on this bill in committee, and I have some real concerns around HIPAA and then also just the chilling effect that this bill could certainly have for people that really need some help, want to seek help, but are concerned if they have firearms and want to go seek help on maybe some of their information would be disclosed and they could get their guns confiscated. There's opponents out there, including the Shooting Sports Association, that argue that the bill erodes trust between patients and providers. If patients believe their therapist or doctor is a gateway to losing their constitutional rights, they may, without criminal information during sessions or avoiding seeking help entirely during a crisis. Critics contend the bill co-ops hospitals into anti-gun surveillance operations. They argue this shift from care providing to petitioning transforms trusted institutions into legal actors, leading partners to view medical staff as arms of the state. Concerns over HIPAA claim the expansion compromises its privacy. The fear is that private health information will be shared with an institution's legal department to facilitate a petition, treating gun owners as second-class citizens who do not receive equal privacy protections. By allowing institutions to petition for gun removal without a criminal charge or prior notice, critics argue the law presumes guilt. This perception can lead individuals to see medical systems as punitive rather than supportive, And opponents also fear that staff who lack intimate knowledge of an individual or who may have personal or political biases could trigger life-altering legal actions, deterring people from engaging with school-based mental health resources. You know, there was an amendment ran this morning by the sponsors to take health facilities out of the community member section of the bill, but they left it in the institutional petitioners section of the bill. So with that, I have an amendment.
There is an amendment making its way to the desk. Mr. Schaffler, please read L15 to Senate Bill 4.
Amendment L15, amend printed bills, page 3.
Senator Pelt.
Thank you, Mr. Chair. What this amendment does is in the institutional...
Senator, please move the amendment.
I move L015.
Very good, L15.
Thank you. What this amendment does is it strikes two sections out of the bill under the institutional petitioner part of the bill. Takes out medical and mental health facilities. You know, if it's good enough to take out of the first part, the individual community members, I think it's just fitting that it should come out of the institutional petitioner section also. So with that, I urge and I vote on L015.
All right, further discussion on L15 to Senate Bill 4. Senator Gonzalez.
Ask for a no vote on L15.
Is there further discussion on L15? Senator Frizzell.
Thank you, Mr. Chair. I just have a couple of words to say about this because when we are talking about healthcare providers being included in this definition of an institutional petitioner, I worry a lot because this is based on this, presumably, the professional opinion that this individual needs, maybe I shouldn't even say professional, the opinion that an individual needs to be removed from their Second Amendment rights. That opinion is based on some sort of interaction with the individual in question, and that's based on either a visit with a counselor or a doctor or whatever. And so this becomes a real HIPAA issue, and I think that we should be very, very careful in this realm. There's a lot of questions that are brought up by this bill, but HIPAA is definitely one of them. It's one thing when you have, as you can in current law, we currently have the ability for a healthcare professional to file a petition, and that would be based on their opinion due to or in part of interactions that they've had with this individual. So when you broaden this and you say, oh, this is an institution, a healthcare institution, whether it's a hospital system or a clinic or whatever, you're not talking about an individual's opinion anymore. This is being brought by a larger organization. And suddenly this individual's rights from a HIPAA standpoint are compromised, in my opinion. So with that, I support this amendment and ask for your aye vote.
Further discussion on L15, Senator Liston.
Thank you, Mr. Chairman. Well, members, I also rise in support of Amendment L015. I'll just go back to, as I mentioned a while ago, I had a constituent call me over the weekend. In fact, he called me early Saturday morning. To my chagrin, he called me like at 6:45 in the morning. That's how concerned he was about this bill. And he is a veteran, and he expressed great concern in the voicemail, of which I did call him back. Mr. Hayes is his last name. And I spoke with him, and he made it very clear in both his voicemail as well as his discussion with me is that even though he does have mental issues. He admitted to that, though he didn't sound like he was off the rail or anything like that. But that he said, I'm not going to go to the VA hospital anymore because I'm more concerned about losing my Second Amendment rights because of what some healthcare worker at the VA hospital or a clinic or wherever he may go. So the very people that might need some help are going to be dissuaded by this bill, unless this amendment passes, to not see their healthcare professional. So it's going to be the law of unintended consequences, is that some of the people that could benefit by seeing their healthcare provider are not going to see it because they are duly and rightfully concerned about losing their firearms. So I think the good senator from Cheyenne Wells is correct in bringing this amendment that deals specifically with hospitals and healthcare facilities and behavioral facilities. So with that in mind, members, I urge an aye vote on Amendment L015. Thank you, Mr. Chairman.
Further discussion on L15? Seeing none, the question is the adoption of L15 to Senate Bill 4. All those in favor? A division has been requested. A few minutes for folks to return to the chamber. All right, members, the question is the adoption on division of L15 to Senate Bill 4. All those in the chamber not entitled to vote, please be seated. Now, all those in favor of the adoption of L15, please stand for the count. May be seated now. All those opposed to the adoption of L15, please stand. At this point, colleagues, the chair is not in doubt. L15 fails. Back to the bill, Senate Bill 4. Further discussion. Senator Liston.
Had to get my stuff together. Thank you, Mr. Chairman. Members, I appreciate the good debate, honest debate that we're having about Senate Bill 4. It's needed, and hats off to both sides for having a reasonable debate about an important bill like this. That unfortunately it's well intended. But I think at the end of the day, we and my colleagues were trying to make some reasonable amendments that just make sense. And with that in mind, Mr. Chairman, I do have another amendment.
There is And amendment coming to the desk. Mr. Schaffler, please read L5.
Amendment L5, amend printed bill
Senator
page.
Wood.
Thank you, Mr. Chairman. Mr. Chairman, I move Amendment L005 to Senate Bill 4.
Properly moved to L5.
Very good. Members, what this amendment does is it strikes the school districts, the private schools, the state charter schools, individual district schools, and institutions of higher educations from the institutional petitioners. And there again, this makes sense because really, people are there for an education, and this ensures that the educational institutions currently that do have some ideological differences in our society will not be able to file these so-called ERPOs. By allowing the educational institutions to file the ERPOs based upon the political beliefs of the pupils or people, the employees, whether they're in the teachers' lounges or the janitor or they're in the break room at at another educational institution, is that what this does under the bill, without exempting the educational institutions, is it weaponizes the ability of somebody to, with that shield of the institution, to say, hey, Johnny or Johnny's parents are a problem because I heard them talking about firearms and about shooting somebody, and they might be talking about a movie. I mean, no telling what they're. So they go, well, and besides, I really don't like Johnny's parents, so all I have to do is just go file this ERPO, and all of a sudden, like I said before, someone's knocking at Johnny's parents to take away their firearms. So really, what this bill does is it supersedes local control. We always talk about local control in the school districts. The school districts are made up of people who are elected by the citizens of that particular school district. They know the parents and the people who are on the school board. That really should be left up to the local school districts. Now, I'll say this, maybe if a school district wants to vote for it, through the school district board, that might be one thing. But to have the heavy hand of the state come down and tell all school districts and other educational institutions that you need to have all educational institutions be able to do this, whether they want it or need it or not, is just not right. And also, this deals with private schools. Many private schools, many or if not most, correct me, they're not even taking state money. And now then they're being told by the state that they have to turn into the authoritarian and to have somebody that can go and take away somebody's firearms. And unfortunately, what this bill also does, it's kind of the law of unintended consequences. It's going to turn many of the people in the educational and the students in the educational arena and the students into a cadre of tattletales, snitches, and false gossip mongers. Is that they've heard something second or third hand, and they go, whether it's right or it's wrong, or they want to get back at somebody, that they can go and file the ERPO. Do we want our educational employees, all of them, no matter how well-minded most of them be, to have the ability that they can weaponize their school and their school districts or their institution of higher learning? So members, I think this is a well thought out, it's reasonable. Let's keep local control. If the local institution feels strongly, then they can bring it to the board and then have an honest debate, rather than us up here telling every local school district and private school and charter school that you must obey the commands of what we are debating here, whether it's needed or not. So members, I urge an aye vote on Amendment L005 to Senate Bill 4. Thank you very much, Mr. Chairman.
Members, the question is L5 to Senate Bill 4. Is there further discussion? Senator Gonzalez.
I rise in opposition to L5 to Senate Bill 4 because, again, I will invite members from my colleagues here and certainly the senator from El Paso County to, again, go to the forms section that when you see the actual petition itself, again, not the first time I've said this, might not be the last time I say this here at the Well during this debate today, again, submitting incorrect information is subject to the penalty of perjury. And to the contrary, this amendment would remove educators from this bill. And y'all, educators already, today in practice, today in law, can already submit these on an individual basis. And so they are part of the rationale to request an institutional petitioner designation. And so this, after listening to the educators directly impacted, that's why we are including the language that we have here in Senate Bill 4. For that reason, I ask for a no vote.
All right, the question is L5, Senator Zamora Wilson to the amendment.
Thank you, Mr. Chair. I don't know about you, but I've seen forms change and become updated such that the verbiage in there can be changed to address exactly what our concerns are. On another note, in regards to the institutions of schools, higher education, I cannot overemphasize that we are in unique times where our state is very much politically divided. And what we're trying to do, what this amendment does, will mitigate abuses. I will say it over and over again. This is Pandora, we're opening up Pandora's box. Because of these institutions and how different the ideology is in the populations, this amendment will mitigate those false ERPOs. It will save the taxpayer money. It will save monetary and non-monetary costs to the taxpayer and to the citizens of Colorado. I urge a yes vote on L005. Thank you.
Further discussion, Senator Liston.
Thank you, Mr. Chairman. Members, just a point of clarification. What my amendment does, L005, is just removes the institution, whether it's the school district, or the institution of higher learning, or private schools. To the good senator from Denver, an individual teacher or employee still has the right under previous law to file their ERPO. This does not negate that. It just that they cannot stand behind the institution and it's anonymous. The good senator from Denver has referred to, there's this form and that they have to sign an affidavit. Well, just because they sign the affidavit they could, under penalty of perjury, well, they could say, well, gosh, I was signing the form under best information. I wasn't trying to be malicious about it. I've heard this or I knew this, and so therefore I signed it, whether it's true or not. So, people sign forms all the time, and then they realize what they've signed isn't necessarily correct, and they go, oh, well, whoops, I didn't realize that the fine print said under penalty of perjury. I didn't mean to do that. I wasn't trying to perjure myself. So all we're just trying to do is, if that individual employee of the educational institution wants to still file the ERPO, they still can, but they can't stand behind the cloak and the mask of the educational institution and the person who's being served. It's anonymous. They don't know where this bolt of lightning has come from. So with that, Mr. Chairman and members, I urge and I vote on Amendment L005 to Senate Bill 4. Thank you, Mr. Chairman.
Members, is there any further discussion on L5? Division's been requested. We will give it a moment. All right, we're back. Members, as a reminder, the question was the adoption of L5 to Senate Bill 4. All those in the chamber not entitled to vote, kindly be seated. Now, all those in favor of the adoption of L5, please stand. All right, you can be seated. Now, those opposed to the adoption of L5, please stand for the count. And the adoption of L5 fails. Back to the bill. Senate Bill 4, Senator Carson.
Thank you, Mr. Chairman. I'd like to speak a bit about, again, about the due process issue. And I think one of the concerns a lot of us have about this bill and similar approaches is the time period that's involved here to file one of these ERPOs, extreme risk protection orders. And the way the law works right now is this process can go on for 6 months. And so, a counselor, a healthcare worker, someone in law enforcement, so forth, can essentially, I suppose, have a concern and then, do nothing about it for quite a number of months, and then bring it up to 6 months later. I think that issue, in and of itself, raises some serious due process issues, and I have an amendment to address that issue here at the desk.
There is an amendment at the desk. Clerk, will you please read L004?
Amendment L4, amend printed bill page 4, line 15, before the...
Senator Carson.
Yes, Madam Chair, I move Amendment L004 to Senate Bill 4.
That is a proper motion. Would you like to tell us about it?
So what this amendment does, actually, I'm going to read the amendment because I think it's pretty direct and self-explanatory. It would insert the following language on page 4, line 15. A petition for a temporary extreme risk protection order must be filed within 10 days of the petitioner's last interaction with the respondent. If it has been 11 days or more since the petitioner's last interaction with the respondent, the court shall not grant the petition. Essentially, the same language would be inserted on page 6, line 12. So I don't see the need to read that paragraph again. But what this gets at the issue of, again, due process. I mean, if you feel strongly enough that a person, based on your interaction with them, is a threat to the community, may engage in the kind of violence that warrants these protection orders and the removal of their firearms and other risk items from their person and from their property. It seems to me that you would want to bring that matter to the attention of the authorities rather promptly. It's not something you want to be able to just kind of sit on for a few months here and there, and all of a sudden you decide, you have this meeting, you have this interaction with someone, what is today, the 2nd of February of 2026, and it's suddenly, I guess you have some sort of concern at that point when you have a meeting or an interaction with that individual. And then you just kind of think about it for up to sometime in July. Sometime in July, it suddenly occurs to you, you need to view this person as an extreme risk to the community. And I do think that raises some serious questions about how this is going to be implemented. And indeed, that's the way it does operate under current law. You can wait up to 6 months, and I think that's something we need to address. This amendment states that an individual or institution must petition for an ERPO within 10 days of that individual or institution's last interaction with a respondent. The amendment ensures that individuals and institutions must act quickly to file an ERPO. Under this amendment, or under the bill as it's currently written, ERPO petitioners would have up to 6 months to file a petition, allowing individuals and institutions to have power over the Second Amendment rights of Coloradans for far too long. And, a lot of people think about this bill as a Second Amendment bill, as a issue of firearms, which it certainly is. But I think the issue I want to address, and I think a lot of us want to address, is really just the fundamental due process principles of our legal system and of our constitutional framework. And as I said earlier in my comments, this goes back many, many years. This whole concept of due process in our legal system didn't just materialize out of thin air a few years ago or a few decades ago. It really is embedded in the foundation of our whole constitutional system in this country. Dates back all the way, as I said, probably the first written occasion of due process was in the Magna Carta in 1215, where it was established as principle that the government, in that instance it was the king, could not just simply arbitrarily use his authority to imprison people, to seize their property, even to execute them. And so this was handed down through the many decades and centuries through English common law and through the teachings of individuals such as John Locke, who basically said, you know, this divine right of kings, the authority of the government over us to arbitrarily seize our rights, it's wrong, and we need to embed those authorities into a due process system. It's interesting, I'll read from you right back how specific this was. Now 810 years ago, it's pretty amazing, but Clause 39 and 40 in the Magna Carta, no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him and send others to do so, except by the lawful judgment of his equals or by the law of the land. And that, of course, that principle came down then into the English Bill of Rights and after the Glorious Revolution in England of 1688, where the monarch was subjected to the power of Parliament and essentially to due process under the laws. And the English Bill of Rights in 1689, which our Bill of Rights is to a large extent based upon, or at least partially based upon. And so this gets back to the whole due process principle, and whatever your views of the constitutionality of bills of this nature, I would argue that setting that, I mean, that's an important issue, obviously, the constitutionality of it. But as I said earlier, I don't think that's your only consideration, because I think we need to, take a step back and just contemplate whether it's a good procedure to involve all of these institutions, our schools, our healthcare institutions, all of these folks in basically putting a system in place where accusations can be made, and I still would argue largely anonymous accusations, because we don't know what this new form is going to be under this bill. Who's going to sign this form? Is it going to be the general counsel of the institution? Is it going to be an administrator of the institution? One of the amendments that was offered said that at least it ought to be several people at the institution that ought to be signing off on these things, not just one individual there who wants to, again, potentially fill out a form, but we don't know what that form is going to be. The sponsors of this bill are talking about the current form that's being used, but how will this bill actually be implemented? We don't know. And so again, I think under the principles that are laid out, I gave a little history there, but now down to our Sixth Amendment in the Bill of Rights and the 14th Amendment to the Constitution from after the Civil War, I think that clearly lays in place, embeds in place the importance of due process for people being accused of crimes or potential crimes. I mean, this isn't even an accusation of an actual crime. This is just someone's hunch or belief that a person could be a tremendous, serious threat, could commit the type of violence, the horrible violence that we've had committed on occasions in this state and throughout our country that we all certainly want to prevent. But it's always a balance. You know, we have to remember we have constitutional protections, we have due process, and while we want to prevent all of these incidents from occurring, we also cannot just set aside our due process system in this country to try and prevent those from happening. So with that, I would urge an aye vote for this amendment, Amendment 4, offered to Senate Bill 4.
Thank Thank you. Senator Kirkmeyer.
Thank you, Madam Chair. Members, I rise in support of Amendment Number 4 to Senate Bill 4. Wow, that was easy. Members, is looking through the law and the changes here in this bill with regard to the definitions, it speaks to adding in a new definition for who a community member is. And it adds in a co-responder who is part of a co-responder community response, as defined in Section 2432-3501, subparagraph 8, subparagraph D. And that in their capacity as a co-responder, interacted with the respondent or the respondent's child within 6 months before requesting the protection order, but who is not a law enforcement officer who responded to a behavioral health related call involving the respondent. So here's what it says in 2432-3501. It says that a co-responder response means a model of criminal justice diversion that pairs law enforcement and behavioral health providers to intervene and respond to behavioral health related calls for police service. Utilizing the combined experience of the law within law enforcement and behavioral health specialists to de-escalate the situation and help link the individuals with behavioral health issues to appropriate services. Makes sense. I don't have an issue with the definition. I just have an issue with the who's interacted with respondent within the last 6 months, because as you read through the bill, as already stated, there is an issue with regard to due process, I believe. I'm sure I'm going to get an argument why there isn't. But due process. So an incident happens where the law enforcement officer comes and a behavioral health specialist goes on the police call with them 5 months and 24 days ago. And now the behavioral health specialist is saying, I think I'll file a temporary petition or file a petition against this individual. Is that reasonable and good faith, first of all? Because in this bill, it also talks about that clinical records of the respondent, when made reasonably and in good faith, shall not be the basis for any civil, administrative, or civil liability. So there's the protection of the behavioral health specialist that needs to be considered. But then for the individual, 6 months later, after some incident occurred with regard to a police call, they now have a temporary order filed against them. Where is their due process? I mean, this does make sense that it should happen within a number of days. It shouldn't happen within 6 months. How does that behavioral health specialist actually, I mean, they may have had one interaction with this individual. Maybe they've interacted with them over 3 days, got them the resources they needed, de-escalated the situation, got them the resources they needed, and that might have been it. Yet this individual could lose, could have their property taken from them, again, back to due process, 6 months later, or 5 months and 24 days later, or 28 days later. Could have their property taken from them. So I think the amendment makes sense, even though the definition would still say that they would have to have had interaction with the respondent or the respondent's child within 6 months before requesting the protection order. And then the amendment would require that a temporary extreme risk protection order must be filed within 10 days of the petitioner's last interaction with the respondent. Due process for the individual, safeguarding the behavioral health specialists so that they aren't challenged with saying that they were being unreasonable and didn't operate in good faith because they waited 5 months and 24 days to report anything or to file a petition. Mental health should be about a safe place, not necessarily a legal trap. We've all been trying to encourage people to get additional mental health, to seek mental health. This bill, the way it's defined, and that, 6 months later, 5 months later, regardless of due process, someone could file a temporary petition order on you, I would think would make people think twice about seeking behavioral health. So I think the amendment, L004, just makes sense. It guarantees due process for the individual. It's not languishing out there for almost 6 months or up to 6 months. It's common sense. And for the institution or for the behavioral health specialist that is now added into here in this co-responder situation. It's in this co-responder situation. Behavioral health specialist goes out with a law enforcement officer, working to de-escalate a situation, not necessarily their client, maybe not necessarily their patient that they will see for the next 6 months. They may hand them off to someone else. I think there's a question as to whether or not it is reasonable and even good faith if they're waiting that long before they file a petition. So I would urge an aye vote on L004.
Thank you. Is there further discussion on L004? Senator Carson.
Thank you, Madam Chair. And I appreciate the comments from my colleague. I think they reiterate very well the points I was making in offering this amendment. And remember, this does not prevent, if you take a situation where someone is potentially counseling someone over a period of months, or someone's meeting or interacting with someone over a period of months, it doesn't really put a time limit on that. What it simply says is 10 days from your most recent interaction with that person. So you might be engaged with this person over a period of time, and things seem to be getting more and more serious. I could imagine, and it's not a topic that I feel, as an attorney, I'm well-versed in mental illness issues, but I've certainly heard of how these things get worse and worse over time. And so it might occur to someone who's interacting with this individual at a certain point, yes, this is potentially a very dangerous person, but there still needs to be some type of guardrails around that. And I would have urged even the current law that we have in place should be amended to put this in, to say, look, 10 days, reasonable period of time. If you really have come to the conclusion that this person is a very serious risk to our community, could potentially kill people, then this needs to be reported. This process needs to be initiated. It's not something you want to just wait around with dealing with. So I think this amendment or similar amendments, down the road we may conclude it's a different number of days, but I think this would begin a discussion on that. And as this bill moves through the process, we would at least end up with some type of a reasonable restriction on the time period here, because I think 6 months from your last interaction with someone, you can still bring a complaint. That raises some serious questions, I think, about how serious the whole matter is when you're reporting it. You're taking someone's rights away from them. So I would urge an aye vote for Amendment 004 to this bill. Thank you, Madam Chair.
Thank you. Is there further discussion on L004? Seeing none, the question a division has been requested. A division has been called. All those in the chamber not entitled to vote, please be seated. The motion is the adoption of L004 to SB 26004. All those in favor, please stand. You may be seated. All those opposed, please stand. The chair is not in doubt. L004 is defeated. Please continue, Senator Catlin. There is an amendment at the desk. Will the clerk please read L006?
Amendment L006, amend printed bill, page 4, line 25, after order, insert, a court shall not grant a petition.
Senator Catlin.
Thank you, Madam Chair. Madam Chair, I move amendment number L006 to Senate Bill SB 26-004.
Thank you. That is a proper motion. Please tell us about your amendment.
Thank you. This amendment states that if a petitioner has engaged in documented domestic violence in a domestic violence incident with the respondent, an ERPO petition is not enforceable. This amendment ensures that past abusers cannot file ERPOs against their victims. Currently, a documented domestic violence incident between two parties must be disclosed within an ERPO petition. However, the decision to authorize the ERPO itself is still left to the discretion of the judge. Victims of domestic violence should be allowed to arm themselves against future harassment from their abusers. This amendment will ensure that prior domestic violence disputes will be a non-starter for abusers to unfairly disarm their victims. By ensuring the individuals with domestic violence records cannot file ERPOs to disarm their victims, this amendment will support the Second Amendment rights of Colorado's most vulnerable constituents. Colleagues, this is an amendment I think that makes sense. We are in the business of trying to protect the vulnerable. And if someone is trying to game the system to where the victim is now the one who's the subject of the ERPO and cannot arm themselves, more than likely this person is smaller in stature, not as strong, not as aggressive, yet won't be able to arm themselves in case there's another repeated domestic violence incident. This amendment simply takes a moment to look at a real-world application, not to break the intent, but to give those that may need protection an opportunity to not be cleverly having that opportunity taken away from them. I would urge you to vote yes on Amendment L006.
Thank you. Senator Gonzalez.
Question to the sponsor of L6. How often have you seen this fact pattern be established in the 690 some odd ERPOs that have been granted thus far under current statute?
Senator Catlin.
Thank you, Madam Chair. I can't give you an example, but I would say that one would be too many. So I'm in the process of trying to close one small loophole, not to hurt what you're planning to do, but but to give one individual in the state of Colorado an opportunity. I don't want to foreclose those opportunities.
Senator Gonzalez.
Thank you. And before you get too far, I have another question for you. Help me understand what the response to this proposed amendment has been in stakeholdering this language with DAs and with organizations that exist in order to prevent domestic violence.
Thank you. Further discussion, Senator Catlin.
Thank you, Madam Chair. You know as well as I do that this is your neighborhood, not particularly mine. What I'm talking about is just taking the opportunity to block one opportunity for somebody who is very vulnerable, to give them an opportunity to maybe survive some of these things. That's what we're talking about.
Senator Gonzalez.
Thank you. I think given the response, and I appreciate the response to the good senator from Montrose in regards to this amendment. This is not coming from organizations that work alongside people who are navigating the complicated dynamics that are often involved in domestic violence situations. And this has not been vetted with them. This has not been vetted with district attorneys, at least. And I would say that in light of that lack of stakeholder work, and to the contrary, what we have heard from survivors and victims of domestic violence is that they want these types of protections. They want this type of legislation because for every, again, I will state this statistic, for every 20 extreme risk protection orders that are filed, a life is saved. This amendment chips away at life-saving policy. Ask for a no vote.
Senator Frizzell. Oh, I'm sorry. Senator Catlin, please respond.
Thank you, Madam Chair. I appreciate the good senator from Denver. I guess I don't follow your logic. What I'm trying to do is just from out in the country, give somebody an opportunity that may not have it right now, particularly if the system worked with some clever abuser. And this is one to give somebody an opportunity. That's all I'm asking, is to give a victim an opportunity. Thank you.
Thank you. Senator Carson.
Thank you, Madam Chair. I support the amendment here by my colleague from Montrose. I think, it's just a common sense approach. I appreciate what the senator from Denver is saying, but it really works in reverse too. I mean, if someone has been the victim of domestic violence, they ought to have the right to possess a firearm and to seek the training and the skill to defend themselves. And you can certainly envision, again, I don't have the statistics either, but the unfortunate thing is domestic violence is a significant problem in our society, and it's probably growing worse. And I think a lot of folks that are victims of that are turning to the ability to defend themselves, particularly if you're talking about women who have been abused by their spouses. They need the protection of a firearm in some cases, and you can certainly envision a situation where the perpetrator of that domestic violence is going to use a tool like a ERPO to cause more harm to the person that they've been abusing. And so I don't think this is something we need to dissect in great detail. It just seems to be common sense to me that you would put this kind of a protection into the bill, that in those circumstances where someone has been a victim, they ought to, the process ought to work in such a way that when it's pretty clear someone who's been engaging in domestic violence is just using this as a tool to get at the person that they're complaining about, then it shouldn't be something that we have in the bill to be permitted. That's something, and even under current law, it's pretty clear that the judge or whoever's reviewing these type of things is allowed to say, hey, this is an obvious case of revenge or retribution for someone that unfortunately this person has been engaging in domestic abuse against. So I think it should be a two-way street. The protection should be in place for the victims who can basically, be protected from these type of revenge or retribution type situations. So I would urge an aye vote for the senator's amendment here.
Senator Gonzalez?
I wish that the definitions of victim and assaultative party were as clean as the good senator from Highlands Ranch wishes that they were. They're not. I want to tell you a story as to why I am so vehemently opposed to this language. An incident takes place. Husband throttles wife by the neck. Wife responds, scratches husband in the face. Neighbor calls the cops. Cops show up. Wife, monolingual Spanish speaker. Husband, English speaker. Husband has a scratch. Wife gets arrested. Bruises didn't pop until after the arrest had been conducted. Ask for a no vote on this amendment. We can keep going if we want to.
Senator Frizzell.
Thank you, Madam Chair. I'm very grateful for the good senator from Denver's example, because it's one that something like that I wanted to talk about. The senator from Manitou Springs and I happened to run legislation last session around essentially financial abuse from one spouse to the other, and whether that could be considered in spousal support determinations, because it happens. And what we found out is this kind of thing happens a lot, where you have one spouse who is essentially being gaslit and the legal system is being gaslit by the other. And as it turns out, I'm just going to read a couple of excerpts from this publication online called The Attorney at Law magazine. The article is titled The Silver Bullet Method, The Rise of False Allegations in Divorce and Custody Cases. This was published March 3rd, 2025 by, the journalist was Padida Jafari. And I'm not going to read the whole thing because it's quite long, and I'm sure you all have better things to do. But this is a real thing, and so I don't want you to think that we're just like making this up. It starts, a few things can sidetrack a divorce case as effectively as an allegation of abuse, especially if that allegation turns out to be false. Unfortunately, such claims are becoming increasingly common. Known as the silver bullet method, these false allegations have become a strategic tool used to gain an advantage in court proceedings. The approach, referred to as both the silver bullet method and the nuclear option in legal circles, can have a devastating impact, immediately separating people from their homes, children, and assets. This is a thing. And there's lots of facts and figures in here. One thing that I think is also important to this conversation, I've skipped down. The financial burden of defending against false allegations is considerable. Domestic violence trials can cost anything from $10,000 to $15,000 in additional fees on top of existing divorce or custody proceedings. However, the emotional toll is often even more severe. Members, this amendment, L006, is really about just this. Just as I stood before you last year asking to protect women who were being financially abused by their husbands, this has to do with victims that are being falsely accused of mental instability, whatever, call it whatever, by a spouse or a partner. This happens. It happens with increasing regularity, and it's something that we really need to protect our citizens from. This is a simple request, a simple amendment that will help protect those who are being preyed upon. Urgent aye vote on L006.
Thank you. Senator Zamora Wilson.
Thank you, Madam Chair. I did a quick research regarding protection violation rates. So where we see re-abuse after intervention and also fear of retaliation. Just a quick stat, roughly 40 to 70% of protective orders were violated at least once. So that shows that this is a real issue as far as using this as retaliatory. I urge a yes vote on L006.
Thank you. Is there further discussion on L006? Seeing none, the question before us is the adoption of L006, SB 004. All in favor, please say aye. Aye. All opposed, no. No. L006 fails. To the bill. Senator Bright.
Thank you, Madam Chair. To the bill. We've had a lot of discussion today about Senate Bill 4. We've talked a lot about the pros and the cons of this potential new statute, and I think I found something that maybe would appeal to both sides. And let me talk to you a little bit about it. We do know that abusers, domestic violence abusers, weaponize the legal process to maintain control over their victims. They do it intentionally. We know that those victims of domestic violence have the fundamental right to self-defense. And so we need to respect that. We need to make sure that that is taken care of, and that basic right to self-defense is preserved. And with that, I have an amendment.
There is an amendment at the desk. Mr. Schaffler, will you please read L010?
Amendment L010, amend printed bill, page 4.
Senator Bright.
Thank you, Madam Chair. I move Amendment L10 to Senate Bill 4, and Amendment L10 I'll let you know a little bit about what this does on both page 4 and page 6 of the bill. It shall not grant a petition for a temporary extreme risk protection order if the petitioner is the assaultive party of sexual assault, harassment, or stalking in a previously filed criminal case against the respondent in the current petition for a temporary extreme risk protection order. So this is what happens in real life. The abuser commits a documented sexual assault or harassment or stalks the victim. The victim then obtains a protection order and/or criminal charges are filed. The victim legally purchases, per her Second Amendment right, a firearm for self-protection. She's being abused. The abuser then sees an opportunity within the system and files an ERPO petition claiming that the victim is dangerous because she has a weapon and she's trying to defend herself. The abuser cites the victim's angry and emotional behavior, which are natural trauma responses that abusers have, that the abused has. The abuser points to victim's firearm ownership as concerning. The abuser may fabricate threats or exaggerate statements made in anger. And the court issues a temporary ERPO. The victim, who's just trying to protect herself, does what she knows to do, and her firearm is seized as a result. The abuser now has a tactical advantage. The victim is disarmed, and the abuser may remain armed. I feel like this amendment is important, and I feel like there's credit that all parties of debating both the for and the against in this legislative Senate Bill 4 can agree on. We need to be able to preserve the rights of that person to be able to defend themselves. When documented evidence exists, such as convictions, protection orders, or police reports that the petitioner has abused the respondent, we shouldn't just rely on the judicial assessment of credibility, because those abusers are skilled at manipulating that system. We establish a categorical bar. You cannot use the legal system to disarm someone you have a documented history of victimizing. I feel like Amendment L10 recognizes this situation and provides for the abused to be able to continue to defend themselves. And as such, I would request a yes vote on Amendment L10.
Thank you. Is there further discussion on L010? A division has been called. But no motion we did make. He did move it. A division has been requested. All those in the chamber not entitled to vote, please be seated. The motion is the adoption of L010 to SB 26004. All in favor, please stand. Thank you. You may be seated. All those opposed, please stand. The chair is not in doubt. L010 fails. To the bill, Senator Zamora Wilson. Sorry, spent too many years in the House.
Thank you, Madam Chair. Colleagues, I cannot overemphasize how this bill is going to be a threat to the expand in an already burdensome ERPO system. And it will inflict unnecessary harm on innocent citizens and strain our tax dollars and erode the very fabric of trust in our institutions. Again, we can look at this. It is going to undermine the Second Amendment, our right to bear arms, especially when you're talking about broadening the list of petitioners to include K through 12 schools, higher education institution. These are areas where they are not equipped or trained in this arena. It's an infringement on law-abiding citizens where the bill targets gun owners rather than criminals, violating the right to keep and bear arms for self-defense. It makes it easier to seize weapons based on third-party complaints rather than criminal charges. We talked about how it's a violation of the 14th Amendment with due process. You're seizing people's property without a chance for them to defend themselves and know who is accusing them, which of course undermines the Sixth Amendment, where we have the right to confront our accusers. So not only that, even though it's been said this is constitutional due to the judgment of Colorado judges, I will say it again, they have been wrong. I also mentioned how this is going to have monetary and non-monetary costs, not only to the taxpayer, but to those that are being accused. We will see increases, even though there's no fiscal note saying there's no impact. When it comes to the taxpayer, we know that there's going to be an increase in ERPO reports. The sponsors say this is going to save lives, so we know this is going to increase demand. And with that, an increase in judicial workload and staffing, an increase in court-appointed defense lawyers, an increase in law enforcement time and resources, an increase in gun storage and management, an increase in lawsuits from falsely accused ERPO reports, an increase in demand for ERPOs and program administration, an increase in compounded costs from SB 25003, an increase in public education and outreach campaigns, and that's just the monetary costs. for the taxpayer. Looking at non-monetary costs, time in court and judicial backlogs will be increased. An increase in strain on the local governments and law enforcement. We'll have the unintended consequences and the chilling effect on mental health and education access, where people will, who, if they're fearful of losing their weapon and they have mental issues that need to be addressed, will not seek help, which is really what this bill is also trying to address, is getting people help. Also, there'll be potential for ERPO violations and criminal prosecutions. And all with that comes the erosion of public trust and community division. That's just on the taxpayer side. For those individuals who are falsely accused, we have cost of a defense lawyer if they go and they seek their own lawyer. We have the increase of gun storage fees, the increase in renewal fees, fees for ATF Form 4473 and background checks, an increase in the ability to transfer weapons due to SB 25003. They may not even get their weapon back with that one. So that's another cost. We have an increase in time without a weapon for self-defense, which will impact greatly people like me. There'll be an increase in time in court for that individual. Time is money, money is time, and it pulls them away from their employment and life. Also with that, non-monetary costs of stigma and public record impact. These records are permanent. They will impact people who are falsely accused. I mentioned about the military, our security clearances. This will impact that. In my district, we have 5 bases. This is going to impact my people. There's also the emotional and psychological stress that comes with this. The inability to hunt or using weapons for recreation. I have many friends who are in groups that they use weapons for recreation, and the potential employment and licensing that the ERPO will impact. These are all costs. So when I hear that there's no cost, I disagree. I disagree greatly. In fact, I would like to request for another analysis on the fiscal note due to all these situations that I have just outlined.
Senatorial 5 has been called. Thank you for our senatorial 5. We are back. The fiscal analyst, there was a request for a new fiscal note. We did consult with a fiscal analyst and have determined there would be no change in fiscal impact, so we are ready to proceed. Is there any further discussion on SB 26004? Seeing none, the question before us is the adoption of SB 26004. All in favor, please say aye. Aye. All opposed, no. SB 26004 is adopted. Mr. Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
Thank you. There's been a motion that the committee rise and report. All in favor, please say aye. Aye. All opposed, no. The committee will rise and report. Okay.
Kathy, you ready? Okay. Yep. You guys ready? We are ready. Okay. Senate will come to order. Senator Kipp.
Thank you, Mr. President. The committee has met and has had a bill under consideration. Will the clerk please read the report?
February 2nd, 2026. Mr. President, your committee of the whole begs leave to report has had under consideration the following attached bills, being the second reading thereof, and makes following recommendations thereon. Senate Bill 4, as amended, passed on second reading and ordered engrossed and placed in the calendar for third reading and final passage.
Mr. Schaffler, before we vote on anything, please add Senator Hendrickson to the roll. Senator Kipp.
Thank you, Mr. President. I move for the adoption of the committee of the whole report.
The motion is the adoption of the committee of the whole report. Are there any aye votes? No votes? Senators, Mr. Minority Leader, Frizzell, Kirkmeyer, Zamora Wilson, Rich, Liston, Baisley, Catlin, Pelton R., Carson, Bright, Pelton B. With a vote of 21 ayes, 12 noes, 0 absent, and 2 excused, the committee of the whole report is adopted. Senate Bill 4, as amended, passed in second reading and ordered engrossed and placed in the calendar for third reading and final passage. Governor's appointments. Consent calendar. Mr. Schaffler, please read the appointments listed on the consent calendar.
Members of the Colorado Water Resources and Power Development Authority, effective October 2nd, 2025, for terms expiring October 1st, 2029. Roy Heald of Colorado Springs, Colorado, to serve as a representative of the Arkansas Drainage Basin and as a representative with experience in the planning and developing of water projects appointed. Karen Wogsland of Steamboat Springs, Colorado, to serve as a representative of the Yampa White Drainage Basin reappointed.
Majority Leader Rodriguez.
Thank you, Mr. President. I move for the confirmation of appointments listed on the consent calendar, which include Roy Held of Colorado Springs and Karen Wogsland of Steamboat Springs for the Colorado Water Resources and Power Development Authority.
Any discussion? Seeing none, the motion is the confirmation of the appointments on the consent calendar. Are any no votes on the consent calendar? With a vote of 33 ayes, 0 noes, 0 absent, and 2 excused, those appointments are confirmed. We'll take a senatorial 5.
Senate Article 5. It's all your fault.
Here we go. Oh, yeah, we back in the game. Introduction of resolutions. Mr. Schaffler, please read the title of SJR 008.
Senate Joint Resolution 008 by Senator Roberts and Representatives McCluskey and Lukens concerning honoring Colorado's 2026 Winter Olympians and Paralympians.
Majority Leader Rodriguez.
Thank you, Mr. President. I move that Senate Joint Resolution 008 lay over until Thursday, February 5th, 2026.
The motion is to lay over SJR 008 to Thursday, February 5th, 2026. All those in favor say aye. Opposed, no. The ayes have it. SJR 008 will lay over until Thursday, February 5th, 2026. Mr. Schaffler, please read the title of SJR 009.
Senate Joint Resolution 009 by Senators Danielson and Catlin and Representatives Johnson and Espinosa concerning the recognition of Missing Persons Day.
Majority Leader Rodriguez.
Thank you, Mr. President. I move that Senate Joint Resolution 006, is it 9?
9, yep.
9, lay over until Wednesday, February 4th, 2026.
The motion is to lay over SJR 009 to Wednesday, February 4th, 2026. All those in favor say aye. Opposed, no. The ayes have it. SJR 009 will lay over until Wednesday, February 4th, 2026. Announcements. Senator Mobley.
Thank you, Mr. President. The Joint Budget Committee will be meeting across the street. Today is the day we take public testimony, and we have a lot of people lined up to testify, so hope we'll move things along. Thank you.
Very good. Senator Wallace.
Thank you, Mr. President. Just announcing that tomorrow we have moved rooms for state affairs. We will be in the old Supreme Court chambers.
Very good. Senator Colker.
Thank you, Mr. President. Announcement that Senate Education will meet 15 minutes upon adjournment in room SCR 357. We have a few appointments and one bill, Senate Bill 19.
And Senator Colker.
Thank you, Mr. President. I request a moment of personal privilege.
Granted.
Members, this year I'm getting it right because it's Monday instead of waiting till Wednesday or Friday in some cases since I've been here. This week is National School Counseling Week, and I'd like to just have a shout out to all of our school counselors, my wife included, who is a school counselor in Littleton Public Schools. Just going to give you a little bit of overview here. So many of us have experience with school counselors in our experience growing up, but today want to just make a highlight here that so many of our school counselors are working well above the recommended ratio of 1 counselor to 250 students, some working at double or even triple that number. During School Counseling Week, the national focus reminds us that when students feel safe, supported, and known, outcomes improve. Attendance increases, disciplinary referrals decrease, and students are more engaged in learning and better prepared for life after high school. Some of the things that we've heard in the past and are currently still being done from our counselors, what they help students do is manage stress, anxiety, depression, and emotional challenges that affect learning. And I think it's more apropos for what we've been discussing today. They support students and families during emergencies, threats of harm, and traumatic events. They connect families to mental health care, food assistance, housing support, and other community services. So besides getting them ready for after they graduate, there's so many things that go on during their lives that today, while they're in school, that our counselors help our students and families navigate. So I just want to appreciate our school counselors this week and remind myself to buy my wife flowers. Thank you.
Very good. Smart. Senator Weissman.
Thank you, Mr. President. Judiciary Committee members, we will get going at 2:30 in the old Supreme Court. 15? All right, well, I think that's only adjournment, but to play it safe, we will start precisely 15 minutes after adjournment or recess, whichever of those two obtains here in a few moments. See you over in old Supreme Court. Thank you.
Very good. Senator Marchman.
Thank you, Mr. President. I wanted to let you guys know, as much as I love you, I did not leave you all Valentines from me to you. However, I did leave you Valentines that you can send to your favorite person. All you have to do is fill out the address wherever you want it to go, and then send it back to me. This is the 80th year that Loveland is doing their mailing program, and the guy's gonna come to my house like every night, so to pick up the Valentines. So please do bring me a Valentine for your special someone, and we'll get that remailed out to them. Thank you.
Gotta love Loveland. Senator Pelton R.
Thank you, Mr. President. Tomorrow morning, Tuesday morning, the weekly Bible study. Had a fairly good turnout last week. Be good to have everybody there if they want to come. 7:15 down in the basement. We'll feed your soul and your belly.
Very good. Further announcements. Mr. Majority Leader.
Thank you, Mr. President. I move the Senate adjourn until 9 a.m. Tuesday, February 3rd, 2026.
You heard the motion. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. In the Senate, we'll stand in adjournment until 9 a.m. on Tuesday, February 3rd, 2026.